Dobrze, to witam Państwa bardzo.
Ladies and gentlemen, welcome to our press conference and to the scientific conference. Let me invite you to this conference, which will tackle one of the hardest topics that has been tackled over last few years. We will talk about the rule of law. As you know, Poland and other states are accused of infringements to the rule of law. And one accusation is that judges in Poland are selected and appointed in breach to the principles of the rule of law. And for that purpose, we are organizing this conference in order to present the systems of appointment of judges in other member states, as there should be a single manner of evaluating and assessing all member states. And for that reason, I'm happy that we managed to bring together well-known judges and members of academia and specialists. This conference will be broadcast live in the internet and onto TV channels, and hopefully it will be a guide after this meeting, and it will be a valuable source of information when it comes to the systems and models of appointing judges in all member states. So let's start with the first panel discussion. Professor Dr. Grzegorz Pastuszko from the Rzeszów University. The floor is yours, dear professor. And Dr. Andrzej Pogódek from Cardinal Stefan Wyszyński University in Warsaw. Welcome. The floor is yours.
My się umówiliśmy tak nietypowo.
We have made an arrangement that the younger will start. So let me start and I will present the situation in my region, and then my colleague will continue with the presentation of the situation of Europe, presenting higher standards and a better model. We are supposed to tackle the issue of the models of appointments of judges. And we started from a question: are there any models? Each state is quite specific in terms of selection of solutions, and these models are very specific. Some things seem alike. For example, member states in our region appoint judges in a similar way, and then we go into detail and we reveal some discrepancies and differences. But there are three main groups of states. The first group, it was the group in which the decisive role in the entire decision is played by the parliament. So this is there were two such countries, Latvia and Slovenia. If we try to look further, for example, the Slovenians say that they are the only state in the Central and Eastern Europe, and they are the only nation having their judges appointed by the parliament. But they are not the only one. There is also Latvia. The second group, these are countries where competence is shared in different ways between the executive power or president and the Council of Judiciary. I separate the executive from president on purpose because president is not the executive power in its full meaning. And there are some countries where judges are appointed by the National Council of the Judiciary, similar to Poland. So there is a competent body responsible for appointment of judges. So the executive power, parliament, and president are excluded from this process. And this is the model applied in Croatia, Bulgaria, where we have a powerful council of the judiciary from our perspective, with all the competences vested. So if we make this division into three groups, no matter whether we have a council of the judiciary or not, because in our region this council is present everywhere, in the apart from the Czech Republic. The Czech Republic, they don't have such a council. They use their traditional pre-war model from the Austrian-Hungary times, the 19th century. So we will present the details of the competence of presidents of courts later on. So you will see that this is the model which is quite alike the model applied in the Western countries. After the 1989, after the transformation, and you all are aware of the reasons behind these transformations, all these states of the Central and Eastern Europe appointed the Council of Judiciary, and that was a sign that the countries are changing their regime, and they are getting and adopting democratic way of governance. So the majority of countries were inexistent, and some institutions were in existence. For example, the National Ombudsman or the National Tribunal. These institutions were appointed only and set up only after real transformation. And the National Council of the Judiciary was one of these institutions. So some experts came and said that there should be the Council of the Judiciary, so a representative body of judges, in order to evaluate the candidates. Because if we take a closer look at the competence of the councils, and this element which is of our interest, because sometimes they have some other broader competence, we will see that the role is very important, for sure. But it is an auxiliary and technical role mostly. So the purpose of it is to streamline to states the work of the body which will appoint the judge. So there is a larger, broader professional group will evaluate all candidates, assess them, and they will present their recommendations. Who should be appointed to the function of a judge? Who will make the best candidates? So to take this burden from the parliament during some committee meeting, or to take this burden off the shoulder of a relevant minister, for sure there should be some ministerial unit or some department responsible for that. But maybe this would be officials who wouldn't have given such decision ever, and they wouldn't be able to evaluate the professional expertise efficiently. So the situation is similar throughout the region, and there are some standards applicable to these bodies, and this is something which is important for appointment of judges. So the creation of this auxiliary body, the National Council of the Judiciary, their main purpose is to define recommendations, and they are responsible for the appointment for over 50% of judges. But it has different meaning in different places, because some of these institutions they create separate committees responsible for candidates' evaluation. It is not made by the Council of the Judiciary itself, but the evaluation is performed by somebody else. And that is important because the executive power nominees are dominant in such a case, and that affects the situation because they perform their work and they present the candidates, and the candidates are accepted or not. So it's not necessarily like that the council appoints somebody from its members. If we take a look, a closer look at these detailed solutions, we have Latvia. So in Latvia, it is the national parliament appointing the judge. But the situation is much more complex because the parliament appoints it upon the minister's ordinance acting under the authorization of the National Council of the Judiciary. So it is made of 15 members, 15 jurists, 7 appointed from the judges. So they evaluate the candidates. They present their evaluation to the minister, and out of all candidates presented, the minister requests the Latvian parliament to appoint somebody as a judge. But it's not the end of the story. The first appointment for the courts of the first instance is made for 3 years. After 3 years, we have a review and evaluation of the performance of a given judge. It is made by the evaluation committee, and upon the recommendation of this committee, the judge can be appointed for an indefinite period of time or for additional 2 years. If the opinion is positive, the judge is appointed for an unlimited period of time. For the courts of the higher instance, it is the minister. Minister requests the parliament upon the request of the council, but the judges are appointed automatically for an indefinite period of time. It is very difficult to say what would happen if the Latvian minister, despite this limited period of time, wouldn't renew the appointment of a judge. What would happen? Probably they has such authorization, and the parliament cannot dismiss the request. Of course, in case of the Supreme Court, the situation is also different because the selection will be made, but for the judges of the Supreme Court, the choice will be made upon the request of the president of the Supreme Court. And the president under the parliament request, but under the request by the National Assembly. So this is one example. The second example is presented by Slovenia, and this is well known from this perspective. There is the Council of the Judiciary. The jurists are dominant there. They are also carrying out and they're involved in disciplinary proceedings. They have their disciplinary unit, which is dependent on the Supreme Court. So within our understanding, such a council is carrying out its proceedings, and as soon as the proceeding is completed, a relevant request is forwarded to the parliament, and the parliament can dismiss such a request, and it is decided by the act, and it regulates what happens next. It says that the Council of the Judiciary may present another candidate from the list of recommended persons, or they can present the same candidate which could be accepted by the majority of votes. Of course, the Supreme Court, for example, can dismiss such a request. So the procedure is to some extent political, because it happens that the National Assembly rejects the candidate which is suggested by somebody else. Of course, the decision of the National Assembly is out of the judiciary control, but administrative court can supervise whether the proceedings before the council was lawful. And we have also institutions appointing the judge, but somebody else is responsible for the placement of this judge in a given location. So there will be the Minister of Justice. So the person who appointed the judge will tell, you're a judge now, and now the minister will define and will appoint you to and assign you to a given court. In Poland, these two things are joined. Of course, it can, in other countries, it is, these are two separate things. Of course, it is responsible from the perspective of retirement of a judge. So if in the Appointment Act, the judge is not placed in a given court. Then we have the largest group of states where we have the split of competence between the Council of Judiciary and the President. And here, this is the Polish case. I think that the Polish solutions are well known to the majority of you. So on the first stage, we have the National Council of the Judiciary, and it recommends candidates to the president, and we have a decision made by the president to appoint or to dismiss a candidate. The president doesn't have to justify it. It is the president's prerogative with no possibility to appeal. Of course, the proceedings before the council can be under scrutiny. So the proceedings before the council or before any other committee, and this is visible in many political and judicial regime all around Poland, this is a stage of appointment of a judge, and this is a part of decision-making process, because that could be shifted to the previous stage, and we should define who can apply for a judge. Maybe there is some kind of examination, and somebody can be rejected from sitting such an examination. So maybe the selection will be made at an earlier stage, like that they would like to be a judge, and so I would apply, and I would proceed. No, they would say from the very beginning that such a person, such a candidate didn't pass the exam for judges, and they would be rejected, that they would point out the moral standpoint of that person, and such a person would be dismissed at an earlier stage. So such an element would also be possible. And Minister of Justice or the National Council of the Judiciary would need to include such stipulations in their regulations. So it doesn't make any sense to talk about Poland.
There's Romania, which serves as an example and as a counterexample at the same time, because also it's at the motion of the president, but the president is not bound and cannot reject. And the Romanian Act says that the president's role is strictly formal. But that's not entirely true either, because if we go down to the level of the military courts, there are such in Romania, then you will see that it's a bit different. So that's marginal, but you'll see that for a person to become a judge of the military court, and then the Minister of Defense has to agree to that person to be ranked as an officer. Otherwise, it is impossible for that person to play the role of the military court or be moved from a civil court. So the final decision is a joint decision of the Council and the Minister of Defense in Romania, quite like in the case of promotion, etc. So again, this is an example that's very rare in our region, because outside the Supreme Court, usually the rules are exact and the same, and very rarely are there separate rules for military courts. But Romanians did make such an exceptional solution, where they weakened their powerful council, and it's really powerful indeed, with very large remit. And they did that under certain external pressure. Both Romania and Bulgaria are states that in terms of the judiciary and anti-corruption are under a control mechanism, supervisory mechanism, that is, they are being appraised against certain criteria. So that external pressure did cause the current Romanian government to have that particular exception. Then, another group of countries are such that have similar situation, that is Estonia for that matter. Also, the president appoints, but there is no council, no judiciary council. So, which does not mean there is no impact of the judges, absolutely not, because the decision is by the Supreme Court. The president can reject, but there's the in cases of security of the state and similar situations. If we're talking about Latvia and Estonia, you will see that there is a very in-depth control of candidates in terms of state security, loyalty to the state, etc. There's a lot of room devoted to that. That is supervision, control, where their intelligence is involved in the appraisal of the candidate. From our point of view, if somebody tried to put in such provisions for every candidate for a judge to be appraised by the Polish intelligence, then that would be very controversial. Because in their case, that's a condition for being a candidate. And if there's a negative appraisal by the intelligence service, then the candidate cannot go on. So the candidates are put forward, and at the motion of the president, the Kobu appoints the candidates, and there is the opinion of the council. That's the opinion of the judges of the Supreme Court, actually. So if you are a Supreme Court judge in Latvia, then they co-create the judiciary in those conditions with this condition of pre-selection. And then Lithuania. Lithuania is diverse because there's the president. In the case of regional and provincial courts, and in the case of major courts, there's the president, and there's a previous appraisal by a council of the judiciary and a specialized council with the representation of judges. That is a commission, qualification commission. Sorry, the council is composed of judges, while the committee is not composed of judges. So at the motion of the president, the decision is made by the parliament. But to make things more complicated, the president is not bound by the appointment of the president of the Council of the Judiciary. It's not that the president has to choose among three candidates or reject 2 out of 3. The president can say, I don't accept any of the 3 that were put forward to me. So, another model is where all the bodies are involved, the president, the council, the judges, etc. And there's this separate recruitment council. And quite clearly, and what you might have seen in your brochures, is the issue of the publicity. Sorry, the of the sessions of the councils. There's transmission on the internet, which is a very rare thing, actually, due to the spread of remit. Much of the procedure is secret, is confidential, particularly since it's often a one-man process at certain stages, so it's difficult to document the stages of the process rather than announcement. Quite a different issue being that the work of the institution can be followed in the mode of access to information, but that's a different story than a public transmission and the obligation to publish memoranda. And having a right to apply for having access to a memorandum is quite a different story, because it'll take time, it'll be anonymized, etc. The memorandum can be very general, etc. So there's this difference. And confidentiality. The traditional model, that is the Czech model, assumes that the president is key, but not on their own. Because, presidents vary, and we have one of the stronger president roles. Although I know the general opinion is that the Polish president has weak competencies and we have a parliamentary system. I don't agree 100% with that, because competencies will show you that the role of the president is rather strong, quite similar to Portugal. While in the Czech Republic, it's a classical situation where the president needs to have a counter-assignment by the prime minister. So, in the case of this classical parliamentary cabinet system, the role is responsibility for making the decision is moved to the parliament, because that's the case, although it's not a rule in all countries of the region. It's quasi-monarchical. In our case, it's very traditional. In the Czech Republic, the assumption is that the president can refuse, of course, theoretically, but in practice, that would be a refusal on the part of the government, because the president acts on the government's motion in any case. So who picks the judges? The Minister of the Judiciary, in collaboration with the heads, the presidents of the courts, which means that the presidents of the courts do all the hard work. They receive applications from candidates, appraise them, send their opinions to the minister, and the minister receives a full package and makes the decisions, picks and chooses, does not do it on their own. Also, the location is picked by the minister. In Slovakia, the president on the motion of the Council of the Judiciary. Theoretically, they could refuse, but that has never occurred. The Slovak doctrine rather says that it would be acceptable for the president to refuse, but only in a case where the candidate went through the nomination process and then it came out at the last stretch that that person does not have legal training. We led them through the process and the person is not 30 years old or doesn't have the right kind of training, or has some penal history, which might seem strange, but we did have such examples in Poland where there was a candidate for a very long time who was an expert in church law, which is not general law, which does not meet the requirement in the Polish legislation. That might seem absurd, but apparently sometimes such things happen. So in such a case, they come to the conclusion that yes, it's possible. Mostly the council is composed of judges, so classically that's the majority as represented by that factor. Also, in Hungary, formally it's the president, but on the motion of the head of the National Bureau of the Judiciary. It's an independent body. Generally, in the Hungarian system, there's a series of institutions that are called independent. Competency-wise, they are regulated to be independent, but their status is regulated by the Constitution, the Cardinal Act, chosen for 9-year terms, which goes beyond even 2 terms of the Parliament. And most decisions are in the hands of that president, and the procedure is rather complex because there is collaboration with the heads, the presidents of the courts, who are applied to. Then there's an auxiliary body, and the heads, the presidents of the courts, give their opinions to the Bureau for the Judiciary, or the Supreme Court, the Curia. In the case of those applying for the Curia, when they have a decision in hand, then they can address the president to ask for the candidates to be appointed, or come to the conclusion that neither meets their standards. So this actually means that in Hungary, the majority of the power is in the hands of the head of that independent body, not being a judge, picked by the parliament for a 9-year term. What is that institution? What is that position? Well, it's like, taking our Ministry of Justice and taking out the administrative supervision of courts and care of the courts in terms of providing them with computers, printers, paper, locations, seats, etc. That would be a body that takes care of those issues. These are key competencies. They might not be very spectacular, but they are key. So that person also appoints for the particular occasion for 18 months, and then 3 years, and then for an indefinite period. So again, there is also a situation in which the president can verify the judge because they received the opinion of the president of the court about the appointed. And now 2 systems that seem to be dream systems for most judges, or at least some judges. That is, systems where the entire power lies in the hands of the council, a council of judges, which promotes judges, can remove them from their office, etc. That body has the entire power. That is Bulgaria and Slovakia, and the members are appointed by judges in a general election currently. Because since we're talking about this is also about representation of these institutions. Most countries of the region have been providing that representation for a short time, starting from 2016, and in Poland up till 2018, a bit longer, they were not representative. You might remember Austro-Hungarian Empire, monarchy. There was Curia of owners, and there was 1 judge per 50,000 owners. And that's how it was organized in our region up till 2016, 2018. The judge of the Supreme Court was promoted, and the judges of the Supreme Court and the appeal courts had the majority in the councils, although they represent a minority of judges, in fact, and regional judges were underrepresented. And since 2016, the countries in our region have been changing that since not only Poland, in order to provide for a representation, adequate representation of the regional judges. And other countries introduced general election among judges to guarantee proportional representation, so that there's a majority of the regional ones. In Bulgaria, there are a few members that are appointed ex officio, and others are elected, and others are elected by parliament in some cases. They are a minority, they hold sessions in the colleges, etc. So in the case of Bulgaria, it's an even stronger institution because it holds the totality of competence in terms of colleges. And it does 100%, has 100% of power. And it's another issue that they try to have a larger majority than a standard majority. Similar reforms to Poland were introduced by Bulgaria, and this was not only down to the election mode, but also the openness of the sessions and transmissions on the internet were imposed.
Tu jest całość kompetencji i
And it's similar in Croatia, the National Council of the Judiciary, which is independent. We have the majority of judges, 7 judges out of 11 members, and 2 representatives of academia, and 2 members of the parliament, 1 representing the opposition. So here we deal with the majority. They're doing everything on your own to make their life simpler. They appoint some auxiliary bodies with this majority. They guarantee transparency, but there is no mention of the online broadcast. So this is the model that that is suggested. So I leave the floor to my colleague.
Bardzo dziękuję. Mam nadzieję, że mnie słychać.
Thank you very much. Can you hear me? Ladies and gentlemen, first and foremost, let me thank to the organizers of this conference. It's a great honor and privilege for me, but also a great obligation. Hopefully, I will stand up to this challenge. Today, I will talk about legal solutions with regard to the appointment of judges in the Western countries, member states. We applied such a geographical criterion here. For sure, some other criteria could be applied, but this division is in line with our scientific interest, and this factor was decisive. First and foremost, some preliminary remarks in order to lay foundations for the further deliberations. First and foremost, we are aware that Dr. Pogudek has suggested appointment of judges in the EU member states is regulated in details and in a very broad manner. So that forces me to select some key aspects in order to be able to demonstrate the issues which are of our interest. In fact, the models suggested by Dr. Pogudek and mentioned by Dr. Pogudek to some extent, and this is my second remark, they refer also to the Western countries. When analyzing the binding principles of law, we can discern, on the one hand, some models. It is a rare phenomenon that executive power is dominant, and some other models where we can see the combination of different competence by the executive and legislative powers. In the entire process, to a greater or lesser extent, the Council of the Judiciary is involved. The name of this council differs from country to country, or some other auxiliary and consulting body. And there is also the second criterion for definition of this model in the appointment procedure. The Council of the Judiciary is involved or not? I need to tell, and this is my personal remark, resulting from the analysis of a number of different regulations, that in fact, due to the richness of and abundance of these solutions, it is very difficult to determine some legal basis allowing for definition of models. So we will use simplification in order to draw a clear picture of all aspects being tackled. Everywhere, and this is another remark, we're dealing with exposure to a political influence to some extent. This political factor is present everywhere. If we read the literature devoted to these topics, in the Western countries, there is a clear opinion among experts that this exposure to political power is required and this is wanted. The bodies of the executive power and of the legislative power, they participate in the appointment of judges, and that serves for the purpose of offering the judges a democratic legitimacy, and this is the essence of the topic, and that should be remembered. Let me move towards the presentation of specific systems. And here, at this point, a few remarks, first and foremost, with regard to the Federal Republic of Germany. Germany is quite specific, mostly due to the fact that in case of Germany, we are observing a far-reaching engagement of authorities, of the executive and legislative power and their involvement in the process of appointment of judges. Maybe let me stress that from beginning.
Problem jest, tak?
I'm sorry, we're experiencing some technical problems.
Krajowym.
So we have the issues with regard to the national level, but also to the federal level, and I will concentrate on this federal part. Because I just want to let you know about the essence of the problem. In Germany, judges of 5 courts of higher instance, excluding the Supreme Court, the nomination process, and this is a significant remark and significant thing, involves a 32-person commission for appointment of judges. So it is a recruitment committee that is composed in half from the members of parliament to Bundestag and in half from ministers of federal lands. It's worth stressing the manner how this first group is shaped, and I will quote the Act on Appointment of Judges of 1985. This Act states that the selection of a given group is carried out pro rata to the political powers functioning in the Bundestag, and for calculations of the number of members representing a given party, the D'Hondt method is applied. So the chronological order of applications is important here. So people which are selected in this manner represent specific political parties. These are regulations which are set out expresses verbis in the binding act. When it comes to the very mechanism of appointment of judges on the federal level, it is so that the candidate can be presented by the federal minister of justice or member of the committee after a recommendation and opinion issued by the presidium councils operating before and by the courts. So this is this dominance of the judicial factor. The judges present their opinion. After this phase with a simple majority, the selection is made in a secret ballot, and a recommendation formulated in this manner, because it's in fact a recommendation, it is forwarded to the federal government, and the federal government requests and places a request. And the last link in this decision-making chain, this is the President of the Federal Republic of Germany. Of course, his role is of decorative nature, but from the formal perspective, it is the President taking this decision. As I've mentioned before, I will not go into details about the specific German lands. I will just let you know that in part of the federal lands, the decisions on the nominations are taken by the government with involvement of some consulting bodies so it is made based on the recommendations of the judges. And in part of the lands, in other federal lands, the decision is made by the minister, but based on a request of the committee for appointment of judges, which is formed to a larger or broader or lesser extent, because it differs from land to land, and there are some smaller or larger differences. I mean the commission operating on the federal level. Austria is another state. And I'd like to draw your attention to the situation in Austria, where the formal decision on appointment of judge is vested in the Minister of Justice. The candidates are presented by senates operating by relevant courts. It's worth stressing that the Senate's standpoint and recommendation issued by the Senate, they are not binding. The ministers try to respect, and usually respect, the recommendation of senates, but we're not having to do with a decision and with the binding decision. These opinions are not binding at all. Senates are appointed within democratic procedures, and I will not go into details of them now. I think it doesn't make any sense. I will just limit myself to the statement that senates are bodies made of judges.
Dziękuję za tę sugestię.
Thank you very much, because that was breaking my speech. Finland is another state which I'd like to present. The judges in Finland are appointed by the minister under the constitutional law. And here there is a body responsible for issuing recommendation. It is a council for nomination of judges, and there is also an intermediary role served by the Council of Ministers, but the decision-making process is the responsibility of the Council. The Council is operating based on a 5-year term in office. There is a representative of the Supreme Court, a representative of the Administrative Court, one president from the Administrative Court, and one from the Court of Appeal, one from Regional Court, and one president of an Administrative Court. So these are mostly judges, plus one advocate and one representative of academia. The system functioning in Finland is presented as a role model, as a matrix. This is the system manifesting the balance in cooperation, which is carried out between the political and judiciary environments. Luxembourg, another country that should be pointed out. Luxembourg is quite specific because the appointment of judges procedure was not included in the constitution. It is regulated by an act. There are several acts setting out the principles of appointment of judges. In Luxembourg, the nomination decision is vested in the hands of the monarch. So the Great Dutch is issuing such a decision, leading to the final appointment of a judge. And the monarch, the role of the monarch is limited to the traditional ceremony, because the decision is made by a special commission for recruitment and training of the judicial system staff. This is the official name of this body. It is composed mainly of judges. Not only judges, of course, but there are also, this is the general prosecutor at the district court for the capital city, some high representatives of tribunals, the Tribunal of Justice. So this is how the system, what the system looks like in Luxembourg. Spain, another important country, and I'd like to draw your attention to the situation in Spain. The mechanism of appointment of judges in Spain is slightly more complex. The judges of higher instances and of the Supreme Court are appointed by the king, whereas the king's decision requires counter-signature of the president of the Supreme Court and members of the Constitutional Tribunal. So this is not the king's prerogative to appoint a judge. So as soon as a need arises for such prerogative, this prerogative is not more a personal prerogative, and it's we cannot object to that. When it comes to the judges of courts of lower instance, they are appointed by the General Council of the Judiciary. This body is regulated by the Spanish constitution. This body is the executive body of and the management body of the Council of the Judiciary. The Council is responsible for appointing judges, but also for formulating recommendations which are presented to the monarch, and the council shapes the decision-making process and the entire recruitment and appointment of judges. What is significant here, it's the manner of appointment of the council, because the council is made of 20 members. The chairman of this council is the president of the Supreme Court. 12 out of these 20 members, these are judges. 8 of them are not judges. They're advocates and other representatives of other legal professions having relevant competence and at least 5 years of practice in performance of their professional duties. And all these people are appointed by the parliament, by 2 chambers of the Spanish parliament, the Congress of Deputies and Senate. What's important here, the resolution made with regard to this decision is adopted with 3/5 of votes. So a qualified majority of votes is required. Portugal. For many reasons, Portugal is specific because nomination of judges are issued by the highest council of the judiciary. The council is made of 17 members. 2 are appointed by the president, 2 by the National Assembly, 7 by judges from themselves, pursuant to the principle of proportionality. It is worth stressing, and this is very characteristic element, that in Portugal, judges do not constitute the majority, and for that purpose, the Portuguese system was heavily criticized. Of course, there were no infringement procedures being triggered by the European Union, but that shows that the dominance of the political aspect and vesting all nomination competence in the council may lead to the accusation of abusing political power. In France, judges are appointed by the president under the request of the Minister of Justice. And this decision-making process involves the highest council of the judiciary, which is shaped as follows. Within its structure, there is a special section of judges and section of prosecutors. Apart from the president and the Minister of Justice, include 5 judges and 1 prosecutor, 1 advisor delegated by the State Council, 1 person representing profession appointed by the President of the Republic of France or delegated by the President, the Speaker of Senate and the Speaker of the Parliament. Apart from that, this section is made of 5 prosecutors, 1 judge, 1 state councillor, and the head of the National Assembly and the Speaker of the Senate. By 2008, the council was presided by the president. This function was correlated of the President of the Republic of France, which was defined under the Constitution of 1958, because this Constitution expresses verbis, sets out that President stands on guard of independence of courts and judges. So we're dealing with a situation which is quite clear, and regulation which is quite clear, which vests the defense of key values for any democratic country to a political body.
Tak jak wspomniałem,
Like I said, 2008 was the year when changes occurred in the function of the President of the Council, and the function was assigned to the Minister of Justice. And things continue as such till this day. Italy. In Italy, the judges are appointed by the President in concert, or rather under the agreement of the Minister of Justice. That's what the Constitution says, which provides for the competency to be delegated to the Minister of Justice under certain conditions. But facts being as they are, mostly is the minister that assigns the judges. In Italy in general, there is a very far-reaching pre-selection stage. There are specific competition procedures in place, but let me not go into the detail. The President delivers the decision in the form of a decree, under the recommendation of the Supreme Council of the Judiciary. It's another institution. Mr. Pogłódek mentioned the issue of over-representation of the judges of the higher order. So let me pick up on that and tell you that in the first stage of the formation of the Italian system, right after the adoption of the Constitution of the Republic of Italy in the 40s, there was this concern among the judges of the lower order for the council to be formed as it is. And I found Professor Zakrzewska, who talked about this in the 50s. She says that the appointment of no other institution was adopted so badly, like it was in the case of the council, which met the strong opposition of jurists due to the way of its appointment, which is not aligned with the spirit of the Constitution. These rules were thought so that it be also representative of the group of 5,000 of lower order judges. That's just, on the sideline. In any case, the today's council is composed by representatives of all three sections of power. Among the 27 members, the parliament only picks 8. They have to be professors in law or experienced lawyers with at least 15 years of practice. The remaining members are representatives of the Judges and Prosecutors Council. Also, the President, the President of the Council, and now let me move to the United Kingdom. In 2005, significant changes took place in the UK. They reformed the model of appointment of judges under the Reform Act. A commission was created, a commission for judges' appointment. That commission is assigned by the monarch fully at the request of the Lord Chancellor. member of the government responsible for the functioning and independence of the judiciary. 7 members of the commission, also under that act, have to be judges to represent law corporations of England and Wales. The remaining 5 places are represented occupied by people who are not jurists. The candidates are presented to Lord Chancellor by the Commission for Judges' Appointment, the aforementioned commission. The Lord Chancellor can accept or reject. That's discretionary on his part. But if the Commission vetoes the rejection on the part of the Chancellor, then he has no other choice but is forced to file the adequate motion to the monarch, and the monarch makes the final decision. It's a bit different in Ireland. Ireland has seen the accusation of a politicized format of appointment. In Ireland, the judges are appointed by the president on request of the government. The government, on its part, first receives the opinion of a specialized commission. It's an advisory council for judges' appointment, and the council presents a list of candidates, but that list is not binding in its character. The government is not obliged to stick with the proposals of the council. So, it can quite freely pick persons from outside the list, which brought up concerns about discretionary decisions in the area, and some accusations were formed along the lines that the process was politicized. The Netherlands now. In the Netherlands, judges are appointed by an order, the monarch's order. The king acts on request of the Minister of Justice. One candidate, though, is picked by the Council of the Judiciary. The council is formed under a very special procedure. It has between 3 and 5 members. And at least half the members have to be judges. The procedure of appointment of the members is very particular and complex. First, the minister, in concert with the Council of the Judiciary, formulate the conditions. The list is presented to a commission formed by the presidents of courts, representatives of the Dutch Judiciary Association, member of the College of Delegates, court administration representatives, persons appointed by the minister, and the commission recommends to the minister no more than 3 candidates for the position of the member of the Judiciary Council, and then the minister makes the final recommendation to the monarch. And Belgium, ladies and gentlemen. The formal decision in Belgium is made by the king, but in practice, the appointment competency is played by the Minister of Justice, and that decision again is based on the recommendation of the Council. The Council in Belgium is very particular because there are 44 members, and interestingly, they are representatives of different social groups, not only jurists. There are judges, prosecutors, but also representatives of the wide civic society. It's very typical of the country due to its internal conditionalities and the colleges, Dutch-speaking and French-speaking, that co-decide in concert in the process geared towards presenting the monarchs with a recommendation of candidates for the council. Malta. I am drawing to an end here slowly, ladies and gentlemen. Malta is a very particular standalone example. In the case of Malta, also different accusations have been formulated about the process being politicized. Quite recently, changes were introduced, and these changes seem to do away with those accusations, making them unsound. So far, there was a certain discretionary character of the state institutions like the President and the Prime Minister. Before the amendment of 2016, that was the first significant change. Before that amendment of 2016, judges were appointed by the President on request of the Prime Minister's Council. Neither of them had to lend their ear to the judges' associations, so it did not involve any advisory groups on the part of judges. And 2016 brought about changes, like I already said, because under the amending Act of Law, a commission was created for administration in the Judiciary, and that commission has become structurally part of the administration of the Judiciary. The commission had the right to recommend an unobliging character. So, since it was not binding, then the President could continue acting freely, and the Prime Minister also, for that matter, not taken into account the position of the Commission. Last year saw a significant change. It brought new quality to the entire process. Currently, the President has to take into account the recommendations by the Commission for Judges' Appointment. They receive the nomination application with a list of 3 names. And in line with the regulation adopted, they are obliged to pick one of those persons. Otherwise, a constitutional crisis would be brought about. So the changes that I'm mentioning limit the discretionary character of the President's remit as the institution being responsible for the appointment of judges. Again, drawing to an end, let me mention Denmark and Sweden, which have quite similar solutions. Denmark sees the appointment made by an independent council for judges' appointment, while formally the appointment is in the remit of the monarch, on request of the minister. But the institution actually making the decision is the aforementioned council. It is composed of mainly judges, Supreme Courts, regional courts, provincial courts, representatives of the Association of Judges, lawyer of the Lawyers' Chamber, and representatives of the civil society, nominated by the national associations. In Sweden, the appointment decisions are made by the Minister of Justice on request of application processes piloted by a so-called Council for the Nomination of Judges. The Council, before it places its recommendation, addresses the President of the Court to deliver an opinion on the individual candidate, and that opinion is taken into account before the recommendation is issued. Thank you. Thank you very much, ladies and gentlemen. And now
Raz, dwa, raz, dwa.
1, 2, 3, testing.
To proszę Państwa, to
So, ladies and gentlemen, now the time has come for Anna Nadalkowska, PhD, Judge of the Supreme Administrative Court. It's our pleasure to have you. The floor is yours.
która poprowadzi wykład o
Anna Dalkowska will have her lecture on the role of the Judicial Council and the judges' appointment procedure.
Przepraszam, a prezentacja? Czy można prosić? Dziękuję bardzo. Dzień dobry.
Thank you very much, ladies and gentlemen. Thank you very much. Let me thank to the organizers of this conference for their invitation, for having me here, and for the possibility to share my remarks with regard to the role of the Judiciary Council in the judges' appointment procedure, but from some new point of view with regard to the four speakers, and that was the assumptions made. After these two highly interesting presentations on the very manner of appointing judges in different EU member states in both the Western and Eastern Europe, this is the very place to present you the role of the Council of Judiciary in the judge appointment process, especially from the perspective of the role of the council, National Council of the Judiciary in Poland in the context of the last reform with regard to appointment of judges to the Council of the Judiciary, and in the context of the last decisions of the European Court of Justice and the Supreme Court, and from the perspective of the compliance of Poland with the rule of law, and with regard to the judges appointed within this new law. So the manner how the Judiciary Council are adopted, it doesn't follow a single model. So there is no single manner of appointing such council. First and foremost, there is this requirement, even if the countries were states within their sovereign power decided to appoint such a body, there are no principles of setting out the principles of functioning and of appointing this rule. So that all results from the decision and the rulings of tribunals in Strasbourg and from Luxembourg. The member states have their exclusive competence to shape their judicial system, and it is within their discretion, and member states are to decide on the principles of functioning of the Council of the Judiciary, and they are free to regulate this functioning within the scope of their responsibility. So if we were to follow, and if we were to analyze the models of adopted to appoint the National Councils of Judiciary, there are two models in the countries, of course, which have such bodies. The first one is the southern model, and the other is the North European model. What is the difference? The difference is in competence and in the political regime. The competence, so the authorization of this body decides on the role played by this institution in the process of appointment of judges or appointment of candidates for judges. The Southern European model of the councils of judiciary, it stems from the council, is founded based on the constitution and offers broad competence in the nomination process. But these principles are not single. The presentation made by four speakers showed that these regulations are quite complex, and they vary from one country to another. But within this group, we can select and find some countries which have established such a model. It's France, Belgium, Italy, Portugal, and Belgium and Poland also follows this model. So, and it's not within the newly adopted reforms, but from the very beginning of its functioning, this is the model which, upon the adoption of constitution, it has been established and specified in the constitution. The North European model of the councils of the judiciary. Within this model, such a council has a totally different competence, so they govern the court administration, they play their role with regard to managing the court budget, and they have some minor role in the judge nomination process. And of course, we have some countries where there is no Council of the Judiciary. They were already enlisted. I mean, the Council of the Judiciary as an organ standing on guard of independence of judges. So these are authorities and bodies which are engaged in the appointment of judges, but not within the meaning that we understand it. So they do not guard the court's independence. So these countries include Austria, Czechia, Luxembourg, Malta, and Germany. Poland doesn't fall within this model because in Poland, the National Council of the Judiciary is the council that has been established, if we were to follow the history of functioning of councils If we were to place them in chronological order, Poland will find itself on the top of the list. So when it comes to the manner how the National Council of the Judiciary was shaped in Poland, I will refer to and I will quote a part of justification with regard to a very famous case, the Human Rights Tribunal in Strasbourg contested the reforms adopted in 2018 with regard to the appointment of judges to the National Council of the Judiciary. And here we read that neither the Article 6 of the Convention or any other principle of law does not authorize anyone to impose on a member state a specific manner of interaction between different types of powers. So the European Court of Justice, with regard to the Polish cases, but not only, but also with all cases with regard to rule of law and independence of judges, it is always also confirmed by the European Court of Justice, which stated that such a competence was not vested in the European bodies, and this is an exclusive competence of the member states. So as the European Court of Justice created its own competence and stated that despite the fact that such a competence is vested exclusively in a member state, these countries should follow and should be compliant with the principles of law stipulated in the Treaty on the Functioning of the European Union, and so the member states should allocate relevant measures to protect independence of courts. So the European Court of Justice got to thinking that they are authorized to evaluate specific solutions and verify whether such measures were adopted by a member state or not. What is very interesting within this evaluation, this opinion is different depending on a specific case and depending on a model and a specific state. When it comes to the Polish legal order, the National Council of the Judiciary, despite the fact that on the initial stage it was an organ which was regulated exclusively in the Act in 1989, I will stress it once again, it was set up in Poland, and by the adoption of the Constitution, so by the year 1996, it was not a constitutional body, but starting from 1996, it has become the constitutional body. In Article 186, it is stated that the National Council of the Judiciary stands on the guard of independence of courts and judges. And members of the Council are obliged to fulfill this main function of the National Council of the Judiciary. When it comes to the constitutional regulation, it is quite modest when it comes to the specification of the status of the National Council of the Judiciary, but it's worth pointing out another Article 187. In the first sections, the composition of a council is specified. But the last point is very important, the last section, because it dedicates to the national legislator the manner to specify it authorizes it to specify the manner how members of the council are adopted, and it was adopted in 2018. So the act does not set out in the first sections how judges should be appointed. In section 1, it is mentioned that there are 15 judges selected from the judges of the Supreme Courts, military courts, and administrative courts. In the second section, the Constitution says that representatives of other bodies, so the representatives of the executive and legislative power, are selected. 4 judges are appointed by the lower chamber of the parliament, and for by the higher chamber of the parliament. So that specifies how how members of the National Council of Judiciary are appointed. The beginnings of the Polish Council of the Judiciary date back to 1985, and the model, how it functions, has been specified during the round table deliberations. The first council was convened on the 2nd of February of the year 1989 for a four-year term in office. In 1990, I'm sorry, for 4 years. And you can find out the minutes from this meeting. All judges who made part of this council were appointed during the communist time by the State Council. They made their vow, which was totally different from the one which is binding now. They promised to guard the socialist rule of law, so I will not quote now, but it was a totally different vow than the one being presented now. So the vow was also transformed with the transformation. When it comes to the composition of the first National Council of the Judiciary, the majority of judges represented the highest instance courts, the Administrative Court and the Supreme Court, and even 9 judges were representing common courts, and it was really like that. But as you can see, on February there was the first meeting, and the judges who in February were judges of lower instance courts, they got promoted because another layer of the courts of appeal was introduced, and the majority of these judges were appointed to the courts of appeal. According to the Constitution, the National Council of Judiciary is a constitutional, collegial, and independent body. It is very important because there are many different interpretations defining this body. I will just tell you what it is not. It is not a court. It doesn't exercise legal power. So it's not a court. It's not a local self-government of judges. We often hear that it should represent judges, that it stands on guard on the judges' independence, but it's not a body of self-government. It couldn't be, because in its mixed composition there are also representatives of the executive and legislative power and judicial power, so it is not possible for this body to be a self-government of judges. It is not an organ of public administration. There were many complaints with regard to resolutions adopted by the National Court of the Judiciary, and some people started to appeal against the decisions with regard to retirement of judges and other matters. And it has been stated definitely that in the proceedings before the National Court of the Judiciary, the administrative code is not applicable. The place of the National Council of the Judiciary on the landscape of the presented by the Constitution of the Republic of Poland. So we have executive, legislative, and judicial power. On this slide, you can see that the National Council of the Judiciary is put aside. It doesn't fall within neither executive nor legislative nor judicial power. So it's an organ, a body that offers a guarantee to be the guard of independence, so it will fulfill the role vested by the Constitution. Let me point out that this split into 3 powers, it doesn't the conclusion is not that they should compete or fight against. They should cooperate and supplement each other. To confirm what I've said, let me refer to the decision of the Constitutional Tribunal. This is the decision issued in 2007 when the Tribunal explained what does it mean to balance powers. This is the interplay of powers and influence of powers among themselves and complementing each other as well as inspecting each other, because no power can be devoid of the inspection of scrutiny. The separate character and independence of court cannot lead to abolishment of relevant mechanisms. So this mechanism protecting the independence of the National Court of the Judiciary results from this mixed character. So it is composed of the representative of executive, legislative, and judicial power. We have 25 members in total. 15 of them are judges. These are not only 15 judges. 15 judges are selected. The first and another one, the head of the Supreme Court and of the Supreme Administrative Court. There are also members of executive power, so Minister of Justice and a representative of the President during this term in office. A retired judge of the Constitutional Court is a representative of President, so it's the 18th judge in the composition of this council. And we have also members of executive powers, which are 4 MPs, 4 members of lower chamber of parliament, and 4 of the higher. So the appointment can be changed by an act without any amendment to the constitution. So this manner of appointment is rooted in the tradition of Poland. It is rooted also in my professional career. I have over 25 years of seniority as a judge. So I need to tell you that the manner how the council is functioning, it was part of my everyday life over these 25 years. What are the standards of the National Council of Judiciary? What was the situation before and now? So what was the essence and purpose of this reform when it comes to the appointment of members of the National Council of the Judiciary? This model was shaped before 2018, and it didn't meet the standards of independence. So that was due to the composition of the council and the manner how it was functioning. So we had to take these two things into account. So the model, how the council was shaped, and and the composition of it. So what was the situation pursuant to the which I carried out? It showed that the model functioning by 2018 didn't prove useful. And why it didn't prove useful? It was confirmed for many years by the national and international authorities. It was the co-optive model, which didn't allow for a relevant representation of judges of the highest, the higher instance judges had their dominance, and lower instance judges were underrepresented. 7,500, these are judges of district courts, about 20,000 from regional courts, and 300 to 500 the judges of the courts of appeal, and highest court, Supreme Courts, about 100 judges. We have also administrative court at the regional level. As you can see, the courts of the highest appeals, so the courts of appeal, the Supreme Administrative Court, and the Supreme Administrative Court were overrepresented. According to the analysis that I carried out, by 2018, there were only 3 members being the courts of district courts. 3 of them during this 25 years of functioning, and 75% of judges in the entire group of judges. These are judges from the common courts.
The Association of the Courts chose their representatives, but it was different in the case of common courts. They have their associations that had made their agreements among them and appointed the candidates. And so the average judge of the district court had no influence on the choice of the representative to the National Council of the Judiciary. Now, moving on. Within the National Council of the Judiciary, although the Constitution says clearly that the term in office is 4 years, and the first council was appointed for 4 years, and it worked from 1990 to 1994. But along the years, due to the fact that different members concluded their terms before the end of the 4-year term, so the interpretation was that those that took the office after those that left were not chosen for the entire term of the institution of the body, but got their individual terms in office, and as a result, every member, I'm talking about the judges, had their individual term, which determined frequent election, etc. And such a model distorted completely the competition-based nomination model of the judges. Because most oftentimes for one position there was only one candidate, so there was no competition for the positions. And in the previous terms and in the current one, often there are a dozen or even several dozen candidates competing against one another. In 2001, 2011, there was absolutely no judicial control of the National Council of the Judiciary, so there was no way to appeal. And there were no justifications for the resolutions of the Council. Every judge knows that if they were even chosen for the National Council, they could receive a negative resolution with no grounds published. The sessions were confidential, secretive, and the memoranda have not yet been published until this day. So no openness, no transparency, no competition, no grounds for the resolutions, no control, no supervision, and no objective criteria. So all these elements were the grounds for an attempt for a change, and such an attempt was made in 2018. The amendment of the Act on the National Council of the Judiciary came into force, which provided full transparency, competition, full transparency of the sessions. There's a whole time schedule of the sessions of the National Council. You can tune in and listen to the sessions whenever you wish. Obligatory grounds for the decisions and objective criteria for the appraisal of the candidates, which are the requires the assumptions of the reform from 2018. Again, let me tell you how judges were chosen for the National Council. I prepared this example. Let's say that the General Council, the General Gathering of the National Council appointed judges, and that was the end of the story. There were 85 members of the gathering back then. 57, that is 2/3, had to be present, but there was a regular majority. Decisions were made by majority. So, if 2 or 4 others abstained and 1 was against, then the candidate was accepted. I don't know about such a situation, but theoretically it was possible. And possibly it did happen. We don't know about that. It's hard to say that such a candidate was chosen by judges. because possibly it was just 2 colleagues who voted for that person. Now, the model for the choice, how has it been changed? Now it's a 2-stage system. The general belief, erroneous one, is that the assumption is lack of representation of judges in the process, but that's not true. The assumption is that the first stage is one at which the judge has to have the support of the judges. In the first place, they candidate by free will, and they have some minimum support on the part of the judges. That is, at least 25 people have to support in writing that candidacy. Of course, it could be a larger number, but that's the minimum standard defined in the Act. There's a second pathway. Support, not from the judges, but from the civil society. Support from 2,000 citizens. So, the first stage's mandate is either by the population or a group of judges. So, it's imprecise to say that the current model does not assume the participation of judges. The second stage is the choice of the candidates by the parliament, and this guarantees the highest democratic standard, because the parliament is chosen in direct elections. So the candidates that receive the support of other judges and accepted by 3/5 of the votes of the parliament can be accepted as members of the National Council of the Judiciary, and these are the 2 stages illustrated in the slide. Now, let me tell you about some more details and some misunderstandings in terms of the National Council. To give you an idea how the general belief is imprecise, the National Council of the Judiciary is a constitutional body of the legal system, and it is defined with different terms like neo KRS, new KRS, neo KRS, KRS bis, etc. So we as members have to deal with the situation in serious bodies. Like, for example, recently, during an interview, I saw that I was assigned as head of Neo KRS, New Council of the Judiciary. We might still meet new terms. There are no such bodies. There is just the KRS, the National Council of the Judiciary, which is a constitutional body. Another issue. It's also presented erroneously. That is, the Constitution defines that the members, being judges, have to be appointed by other judges. That's not true. The Constitution does not say that. It says that the judges are appointed from among judges of different levels of the judiciary, and it does not stipulate the way they are to be chosen. In the Act from 2017, there is the way to appoint judges, and generally it is believed that it is in line with the Constitution. Let me remind you that in line with the Article 190 of the Constitution, the verdicts of the body are generally a part of the Polish legal system. It is not true that 23 out of 25 members of the National Council are chosen by the politicians. Let me remind you that 15 are chosen in the 2-stage procedure. 2 are functional judges. There are 17 judges. 1 is a president's representative, and others are representatives of the executive and the judiciary. Another myth. It is not true that the Constitution imposes the choice of judges for the Council by judges, and it is untrue that the break the Moroccan terms by the members of the Council in 2018 were against the constitutional order because there were already individual terms that were in place until 2018. So, appraising that model of operation, the Constitutional Court came to the conclusion that was unconstitutional. So, the Council, working between 2000 and 2018, was against the Constitution because the terms should be 4-year-long terms altogether. The Constitutional Court decided that the individual terms were not in line with the Constitution, so, ergo, the break in those terms were not unconstitutional. There is no proof of independence of the National Council. The institutions of the EU often refer to a certain general belief, impression of the wide society about the Council, but there is no individual, though particular proof regarding the members or the procedure of appointing the judges being proving that it is dependent of any kind of power, like the executive or other. The number of appeals in the last term compared to the previous term between 2018-2022 and the previous ones shows that many more appeals were included by the Supreme Court than before, which means that the court controls and supervises to a large extent for resolutions to be repealed. Before it was 1-to-1, and even if there was appeals were usually rejected. So these conditions give no grounds for concluding that there is any question about the independence issue. The Constitution defines the minimum standard of constitutionality, and the rest is left to the Act, like I said. Well, to conclude, let me refer to European verdicts delivered. There were a lot of questions and appeals to the Court of Justice. Some are still in process, and an analysis of these show that there is no question about the Court of Justice bringing into question the independence of the Council in any way. It's a bit different in the case of the Court of Human Rights. But in the case of European Court of Justice, there is no question. Let me show you how it refers to the analysis of the situation in Poland and appraisal of different countries on the example of Malta and Germany. An interesting example of the Maltan system of 2020, my four speakers mentioned about the system in Malta until 2016. And based on that regulation, there were proceedings in the Court of Justice where the court evaluated the standards of independence of the judges appointed in the model that was in place in Malta back then. And it came to the conclusion that the condition in which the judges appointed for the by the executive does not bring about any relationship of dependence between the judges and the organ and the body that appointed them, and does not bring into question their independence if there is no pressure after their appointment and they do not receive any orders during their term in office. So the court says that yes, indeed, independence definitely is the highest value of a rule of law, but it should not be appraised after the appointment. After the appointment, we need to check whether the judge does meet the requirement of independence, whether be it in terms of objectivity and the internal objectivity, externally and internally. And this is no surprise, ladies and gentlemen, because the control, the supervision of independence is well known to the Polish and not only legislative system in penal, civil, administrative, and other. If there is any question about the independence of the judge, there are procedures for suspending such a judge. In such conditions, such doubts about the independence were a motivation for proceedings and leading to the suspension of the judge. Another issue is Germany. Based on the Hessen case, also regarding the formation of the judiciary in Germany. Please note that under Para 3 of Hessen land, the judges are appointed by the Minister of Justice. So the question is, do these judges meet the criterion of independence? Under Article 19 of the Treaty on the European Union, which gives the basis of recognition of the independence of judges, this regards the independence of judges after the appointment, and this was stressed after the General Ombudsman quoted the example of the Federal Tribunal Constitutional Court in Germany. So the court said that the circumstance in general was not decisive in terms of independence of the judges, and if there are any doubts, in each case the conditions have to be looked into in individual cases. And yet another point of the same verdict, and the fact that the judiciary or the legislative are included in the process of appointment of the judge should not bring about questions about the rightfulness of the appointment if there are no doubts about the independence during the term in office of the judge. And the issue of Poland of 2019, please note that appraising our model introduced by the reform from 2018, the Court of Justice came to the conclusion that the fact that the judges are appointed by the President of the Republic of Poland cannot lead to dependence of the judges on the President and bring up any questions about the judges' independence if they do not receive any instructions from the President during their term in office. Referring to the same issue in the same verdict, the court said, of course, there is no obligation to create a national Council of the Judiciary, but if they went for that, then it's a body that is at the guard of the constitutionality. And if it does exist, it can be an element of objectifying, making more objective the process of judges' appointment. So the fact that it exists, it increases the standards of independence of judges. The Court of Justice did not bring into question at any point the procedure of appointment of judges. The ruling only includes elements that I mentioned. So, wrapping up, the organization of the judiciary, including the National Council of the Judiciary, is no different from models adopted in different member states of the European Union. In terms of the issues created by the court decisions by the Strasbourg court, that's something we're going to debate during the next discussion panel, which I invite you to participate in very warmly. There's this fashion for bringing into question the National Council of the Judiciary in light of the European law. But let me remind you once again that the rulings of the resolutions of the National Council are binding, generally binding in the Polish legal order. Thank you.
Raz, dwa. Bardzo
1, 2, testing. Thank you. Thank you very much. Judge Anna Dalkowska, PhD, Judge of the Supreme Administrative Court in Poland. Now, ladies and gentlemen, let's have a coffee break until 2 o'clock, and let's reconvene for the second panel. Very interesting. That is the system of judicial appointment versus case law of national and constitutional courts and the Court of Justice of the EU. You'll find coffee in a room next to this one. Thank you.
dajcie mi ten, to skąd i co.
Raz. Działa.
Można? Dobrze, Szanowni Państwo, pragnę przedstawić uczestników.
Ladies and gentlemen, let me present the panel members. We will talk about the system of judicial appointment versus case law of national constitutional courts and the CJEU. Let me welcome Waldemar Gontarski, professor who has joined us remotely. Welcome, dear professor. Doktor habilitowany Marcin Wielec. Professor Jarosław Szymanek. And Dr. Edyta Krzysztofik. And the judge member of the National Council of the Judiciary, Joanna Kołodziej-Michałowicz. Ladies and gentlemen, when it comes to the systems of appointment judges and the case law of the national courts and European courts, we need to tell that recently we could see intensive case law with regard to the functioning of the Polish judiciary and judiciary in other member states. Before this discussion starts, I'd like to present and reiterate some important topics. First and foremost, the organization of the judiciary is not subject to the EU matters. It is something which is an exclusive competence of a member state. That means that each and every member state has a right to shape the model of the judicial system in the manner which they believe is efficient from the perspective of the tradition, history, and social matters. The European Court of Justice, in his decision, stated that the principle of independence of judges stems from Article 9, Section 2 of the Treaty on the European Union and Article 37 of the Fundamental Charter of Rights and case law issued by the Tribunal and by the European Court of Justice. And together with members of this panel, we will try to respond to this question, because in many decisions, many rulings, the European Court of Justice refers to it quotes that each and every member state can shape this model, but they should provide for the measures of protection of the independence of the judiciary. So the first topic I'd like to tackle today is the definition of a court in the context of the obligation to provide an efficient protection of the judiciary, and how does it fall within this division of power that we mentioned at the beginning. So, dear professor, my question to Professor Szymanek, could you try to respond to this issue? Thank you very much once again. Thank you very much for having me here. I'd like to thank the organizers of this great conference. Hopefully it will dispel some doubts, and let me quote after Mark Twain that before the truth takes on its shoes, the lie will be spread all around the world. And this is how it looks like, and it's very true for the judicial system and for the concept of the split of powers. And all the constitutional principle of balance and the constitutional and indicated in the preamble the rule of coexistence of powers. So we need to take into account that all these principles are put in one basket, that we put it like this, and they are identified by means of similar or identical parallels. And I think they're all leading and heading in one direction to something which was about 200 years ago defined by Montesquieu, this division of power. We need to be aware that this division of power is only one option. When we take a look at the history of political doctrines, we know that there have been a dozen of different divisions, and at the time of Montesquieu, nobody treated the judiciary system as and the judicial power as a separate power. It was just a part of execution of a law, and it's the judicial power is a symbol of execution of power. So among all the doctrines, this judicial power was not mentioned at all. Very often it fell within the executive power, and the monarch was the governor. And we owe a lot to Montesquieu in that respect. Then the power of judgment was defined. If you take a close-up look at the work by Montesquieu, you will read that he was not talking about the judicial power, but the power to give judgment. The authentic and political and active powers, these are executive and legislative power, and the judges are only the mouth of the act. So they are not active players on the political stage. Their exclusive role is to crack the code of the norm and adoption of this norm to the factual state, which should be decided by the court. But the Montesquieu tripartite division was recited all around the world, despite the fact that the very same Montesquieu indicated that there is a kind of ideal model, but he said that it was not the reflection of the regime adopted in France, but only the ideal matrix, as he wanted to create such an idealist system and a system of balance. So Montesquieu came up with the idea that the regime based on balance is not an ideal one, as it doesn't grant and doesn't allow for balance among all the powers, and the division of power also doesn't guarantee the balance. He said that the legislative power is the most important, and as it animates the activities taken by all other powers. So all powers are subject to the parliament. If you read the ruling of the German Constitutional Court, you will read that this dogma of Montesquieu is quoted in Germany starting from the 1950s of the 20th century. They say that the judicial power is not equal to legislative power, because the legislator, through the act of law, define the judicial power, its competence, and modus operandi of its operations. So we are having to do with a kind of doctrine which distorted in a way. And the last word here, being aware that all these intellectual concepts with regard to judicial powers are very varied. We need to become aware that since mid 20th century, there is the process of judicialization of legislation and executive power. Mark Tashner told that the 18th and 19th century were dominated by the legislative power. The 20th century, because of wars, it was the period of dominance of the executive power, and the 21st century will be dominated by the judicial power. And let me present and demonstrate that all what is going on with regard to the judicial power, and I'm taking into account the constitutional judicial power, which was defined after the Second World War. These are elements aiming at strengthening of the role of the judicial power. One of the Human Rights Tribunal decisions was that the Constitutional Court should have the same features as a traditional court, despite the fact that Kelsen, when he was preparing the concept of the Constitutional Tribunal, he put it and he made it quite clear that it's not a court because it doesn't decide on the factual state. So on the actual state. So the Constitutional Court is the court over law, not over facts. So the court established by an act, it's a court that fulfills some basic assumptions of political doctrines that raised along the way. And all elements which, starting from the end of the Second World War, aim at judicialization of the state. These are constitutional tribunals, these are international tribunals which interfere in the discussion on the judicial power, and these are also administrative courts which are an aftermath of the reforms of the 20th century. That's true. In such a case, if the time has come that the judges or the judicial power will, by principle, will try to play the lead role, how to react to this court established by an act, the European Court of Justice, and other interpretations, not only by Constitutional Tribunal, but also the advocate courts. They are courts within the meaning of the European law. So maybe I will refer to Professor Gontarski, who is the practitioner. Could you please refer to this concept? What does it mean, a court established by an act, and to what extent and how member states, including Poland, should fulfill this premise, namely to fulfill the premise of a court being established by an act, how to make it under Article 19 to provide and to fulfill this obligation to provide legal measure of independence of a court. Thank you very much. With regard the 21st century will be the age of the judicial power. The Constitution of the Republic of Poland of 1996 in Article 137, tribunals and courts are separate powers independent on any other power. So our legislator favors such a way of thinking, and they started only in 20th century, but that was with regard to what was said. And now with regard to what you said at the beginning, that the tribunal in Luxembourg, based on 19 of the Treaty on the European Union, they quote this article to lay foundations from the inspection and supervision over the Polish courts, and also Article 19, Section 1, we have of the Charter of Fundamental Rights, we have the right to efficient remedy and to access to judiciary, which is independent and established based on an act. Tribunal and Luxembourg, especially, for example, the case Raczkowicz combines the two things, and for that reason, it will be easier to respond to your question. I can talk a lot, even in a book devoted to the conference organized by Member of Parliament Patryk Jaki in November. I published a paper there, and I quote Professor Leonard, who became the president of the Tribunal in Luxembourg, of the European Court of Justice Luxembourg. So he warned not to extend the rights included in the Fundamental Rights Charter to treaties, to prevent expansion of the competence of the EU institutions. So in the treaties, if there is no mention or established by an act, that the tribunal cannot add something like that. We know that it could be a premise to deal with the Polish reform. Even in the Portuguese judges tried to postulate it in some official papers to their coming to the rescue of the Polish judges, and it seems that the in Luxembourg exceeded its competence, and that was their interpretation. And I was writing like that, and until the moment before I read the Polish National Recovery Plan, and I called it "His Name is 238," and that was a response to everything I objected to. So the fact that this Article 238 shouldn't be taken for this right to the access to independent courts, because if we the article page 200 of the Polish National Recovery Plan, better investment climate and support for the internal system, the regulations 21/241, it is indicated by it will be triggered by the independent courts. According to Article 19 of the Treaty on European Union and equivalent legal documents. So Poland and the National Recovery Plan accept codify this legacy of Luxembourg with acquis with regard to the Polish reform of the judiciary. So page 100 of the National Recovery Plan that changes the entire philosophy of and my way of thinking. And at some point, there was a situation that if the Polish accession plan, when the discussion was underway before it was signed in Athens in 2003, in Article 23 of the accession treaty, which allowed to the European institutions to change the common agricultural policy rule. So between 2003 an accession plan, and 2004, which was the actual accession when Poland couldn't participate in the process already. Then the European Union abused the situation and changed it to the detriment of Poland, and Poland lodged a claim in Luxembourg, and the court dismissed this claim. So as you could see, I'm reasoning like that because we agreed and we codified it. So now let's summarize what exactly we codified.
Well, that's how I prepared for this conversation with you. That is, namely, I recently prepared documents for the National Administrative Court for a case, and it's a case regarding an in concreto text codified in the currently binding act of law, signed already by the president, the disciplinary chamber being independent, in terms of independence of the courts. And this answers the question about the standards that national judges have to meet in light of the Strasbourg and Luxembourg rulings. With Strasbourg, there are certain issues, but taking into account the December 1st, 2020 ruling. But let's stick with the Luxembourg ruling. When I was the plenipotentiary of Poland in terms of a ruling of November 2019, the general plenipotentiary, there is the possibility to for a motion to be received again if a content-wise issue is not discussed, and I was interested in whether, in the fact that it does not make a difference whether the judge was appointed by the executive, like it is the case in Germany. But what's important is, as previous case law shows from Strasbourg and German and British cases and German cases, and the Strasbourg case law demonstrates that a judge is independent in his function, even if they are appointed by a political power, that is, a minister, like in the case of Germany, on condition that at the point of being delivering rulings, they do not receive instructions from the minister and does not follow those instructions. Only if they do follow such instructions, they cease being independent as judge in line with the act of law. And this, ladies and gentlemen, is point 133 of the ruling that I'm referring to of November 19th, 2019. As plenipotentiary of the Luxembourg court, they should factor in the 1984 ruling of December, Campbell and Fell versus the UK. And in para 70, the second sentence says that the judges are nominated by the minister or at the agreement of the minister, cannot be seen as independent just for that reason. And in sentence 3, we read that even if the minister gives instructions to judges, that does not yet mean that they have been what you said in your opinion. Do we meet the condition, the requirement of independence or not? Well, we do not, because what's taken into account is the abstract text, that is, if they were appointed under a procedure that raises doubts, that is, by a minister, although in Poland the minister does not appoint, although they see from the point of view of the new National Council of the Judiciary, there is no new National Council and such a body. There is just the National Council. Yes, but whether does it operate under the old or new act? Sure, I do not accept the term neo-council, but the new council is acceptable for me because it points to the fact that it was assigned under the new act of law. And so in that case, we do not meet the criterion, because the new National Council of the Judiciary was formed under the new Act, but the article the Article 258. But if we take other cases and looking at the Luxembourg case law, in such cases, it's different. Like in February this year, in the Dutch cases, and it says that in abstracto text is not enough. We need an in concreto text. That is, it has to be proven that the given judge is not in line. So under premises of our system, that is sanction of suspension. Thank you, Professor. I don't agree completely, because even in abstracto there was no direct ruling that we do not meet the criteria, and no point and no grounds for any ruling such a formulation was included. Even taken into account the in abstracto, not only in concreto, and in the ANA cases, which I was also participant of in the courts of justice of the EU. In most cases, the court refers to that in concreto text. So full agreement on my part in that respect. But I'm of the opinion that the in abstracto text does not give grounds for that either, and I don't think that the court adopted such an approach in any of its rulings either. Sorry, I want to hand over to... Thank you very much, ladies and gentlemen. Now quite does meet the criterion. The Strasbourg ruling is taken into account. Does it mean the standard of the court in the wider meaning of the effective court and independent court? Of course, different possibilities can be taken into account. The professor says it does not meet it entirely. I would like to take into account the March last year ruling in the case of Malta. Sorry, it's from April. I will say that it does meet the requirement, because in the Malta case, where there is no body such as the National Council of the Judiciary, the Prime Minister appoints the judges, and the Court of Justice of the European Union said that it cannot give a direct answer to the question whether such an appointed judge and judge appointed by the executive, whether they are or are not an apolitical judge, an independent judge. The Court of Justice said that in every case based in an abstracto procedure of appointment, conclusions cannot be drawn about whether the judge is or is not independent, because the issues of judges' independence can be assessed in posteriori, looking at their work done. And let me add that the Polish legal doctrine always has been pointing to the fact that in talking about independence of the judges, we mean two elements. That is the external independence of political factors, but also looking at journalists from the media, so that there are no rulings delivered under the pressure of the public opinion, the media, etc. But also there's independence, internal independence. And that's the core of independence. That is, every judge ruling about every individual cases need to take into account all the factors to be taken into account. That is the praxis so far, the case law, and in line of the context of the proof with their life own experience rule that this is make the ruling, and this is the real judges independent, and one needs to agree with the Court of Justice. As they said, the court said that there is no way to rule based on the procedure as such, whether the judge is independent or not, because the independence of judge is decided by how they perform their work. Thank you. We came to the conclusion that the Court of Justice created for its self-competencies of supervision to form the model of and the application of and the appointment of judges, and since it created for itself such a competency in its rulings, let's try and define what the court takes into account in its supervisory role. Does it have some template of models? Because we know that rulings vary strongly and depending on the member state, among others. So we know that the court has not adopted a single model of control, of supervision. So the question is whether there is any unique model or not. Krzysztofik, please. Thank you. I would like to put some order in this discussion and in the entire interest in the Court of Justice. The analysis of the entire case law points to certain interesting elements. Above all, the court was interested in the notion of courts from the point of view of the preliminary ruling under Article 277. Whether the entity that files a preliminary ruling request is a court or not. So the court has to decide in the first stage functionally whether it's a court that addresses them. So there are 5 control criteria that are checked in the case of every request, whether it can be addressed at the court or not at all. The other element that emerged in the context of the Polish reform, where the court extends to 167 article and covers also the systemic premises. So in the first place, it referred to the request on the part of courts that asked questions, preliminary ruling requests to the court to check whether that court can be treated as a court in terms of meeting independence criteria. But let us not forget that we are talking about a basis in treaties. We have 267 article that introduces the instrument of the preliminary ruling question, and the Court of Justice, by exerting its power stemming from the treaty, checks whether that is indeed a court. Then, acting under Article 47 of the Fundamental Rights Charter, but to check if the court can carry out that control or not, we need to take into account the Charter of the Fundamental Rights. So the competencies of the bodies of the EU. Article 6.1 in the Treaty on the Charter of Fundamental Rights. So it cannot extend its competencies in any way or extend the rights stemming from the Charter. And indeed, the notion of court is directly connected with its treaty-based remit. Now, moving on, let me refer to the reform of the judiciary. There are 2 or even 3 situations. First, sorry about my cough, is the air conditioning. So the first moment is the Court of Justice looks for a touch point with its own competencies and the reform of the judiciary in the member states, which was the case against Portugal mentioned by my fourth speaker, what was the touching point then? The starting point was that the court came to the conclusion that during the execution of the reform, or rather amendment of certain provisions, the state infringed its obligations stemming from the EU directive, so it gave itself the remit to control the member state in terms of the functioning of its judiciary. A similar position was taken by the court in the case of Hungary and in the first rulings against Poland. But then, ladies and gentlemen, so what we are seeing is different degrees in the court's degrees, in its rulings, sorry. And then we go back to the Portugal ruling. A quite newly created mechanism of control. Namely, the court connects Article 19.1, which we mentioned on many opportunities, and Article 4.3, and about loyalty, and Article 2, very often mentioned in literature. That is this operationalization of Article 2, that is, it combines the value on which the EU is based, which should not be supervised by the Court of Justice in general under 258, with loyalty, which very rarely is seen as a basis for starting proceedings against a member state, and the Article 19, which talks of the right to effective legal protection. And based on that, it built for itself its own remit to control, supervise reforms executed at the level of the member states. So, like you can see, the Court of Justice's involvement with these reforms was step by step. At first, it was based in a competency stemming from the treaties, and then it stepped into the exclusive competencies of the member states, and then the Court of Justice created its own method of seeing the exclusive competencies of the member states, because we don't have a closed catalog of such competencies. We do have such a catalog, closed-ended catalog of competencies of the European Union, because the European Union bodies have been given certain competencies, and all the remaining ones are the competencies of the member states. But the Court of Justice came to the conclusion that the member state was executing on its competencies, but while executing its competencies, it cannot limit the application, the execution of the competencies of the European Union. And then there is the application of the very interesting theory. It cannot cause significant discomfort in executing European law, and unfortunately, ever more often we see going around these competencies, exclusive competencies of the member states. Thank you very much. Thank you. So, since it created competencies for its own self, I'm talking about the Court of Justice of the European Union. Since so, let's see how the court assesses the standards of independence and the models of appointment of judges in the member states, and finally whether these standards that it adopts and uses for its assessments have application for the judges of the Court of Justice of the European Union. Since it's a European court, and since it looks into standards of independence of other courts, independence of judges of those courts, one should wonder about whether the judges of the Court of Justice of the European Union do meet these same standards. So first I'd like Mr. Wielec to comment on this. Please, could you comment on the issue? What are the standards of independence as adopted by the Court of Justice, and how they're applied to the members of the Court of Justice?
Szanowni Państwo, ja też
Ladies and gentlemen, thank you very much for having me. I'm listening to all of you, and I'm wondering, do people understand when we're talking about? Because we're talking about case reference numbers, costs versus somebody, Poland versus, and the average citizen is watching us and telling us it's a bubble. We as professionals, of course, but I'm wondering, and here I'd like to refer to the question about the elements and the fundamental criteria of the model. Maybe the reason could become the greatest criterion. As a person who has been running a legal firm for many years, I met some customers who didn't. I had some clients who didn't understand the judgment. So an average citizen doesn't know what does it mean, a test in abstracto and other things. So we can talk about juristocracy, or so maybe reasonocracy would be a remedy. Maybe let's go back to the fundamental rights. It is called the natural law in our system. If something is white, let's call it white. If black, maybe it's abstract. And going back to that, going back to what we're talking about now. But with regard to this topic, I'd like to use a reason and apply reason as one of elements. Of course, this is my wishful thinking, but let it be. If I lowered the level of the interpretation and of the discussion to a simpler language, we have carried out such tests in our institutes. We compared the national councils of the judiciary. We compared all the mechanisms around that, and we have all criteria that you've asked about as other member states. Professor Professor Głodek and Professor Pastuszko have been talking exactly about that. The names are different. There are General Council of the Judiciary or National Council of the Judiciary. There's no single Council of the Judiciary. So there are a lot of models and a lot of elements that, or the judicial system as it is, or the exercising judicial power. So these are doctrinal definitions, and depending on the identity, on history, and on experience, it has different effects. So maybe in this situation, we should tackle the question: what is the role of the National Council of the Judiciary in examining all cases with regards to the independence of judges? And this is my question to Judge Joanna Kołodziej-Michałowicz, who is performing her duty as a member of the council for the second time. So what is the role of the council in fulfillment of this premise of independent judiciary? Thank you very much. Thank you for having me here, and thank you and I'd like to thank to the audience that you're listening to us carefully. It has been mentioned today that the National Council of Judiciary stands on guard of the independence of judges and courts. So we perceive this task as a permanent task. It is up to date, and it touches upon all aspects of our life and all aspects, all activities we undertake. The competition for the position of judges of the Supreme Courts, of the military courts. And if we understand all these postulates that were tackled today, and the postulates of the European tribunals, we believe that our task to guard the independence of courts and judges should be fulfilled with regard to two aspects: evaluation of candidates for judges and evaluation of performing judges. When it comes to this first group, so people who'd like to become judges, so I mean the competition for judges and associate judges, first and foremost, these proceedings, in order to make them transparent, they should be open. This information has already been mentioned today, but let me go deeper. What does it mean to have an open proceedings before the National Court of the National Council of the Judiciary? This is a live broadcast and possibility to watch the records and watch the recording of such a session. Ongoing broadcast and continuity of the broadcast is being monitored throughout the broadcast. If the IT department informs us about any irregularities or interruptions, the deliberations are stopped until the technical glitches are overcome, and only after obtaining a confirmation that the broadcast can continue, the deliberations are resumed. Everyone can get an access to the recordings as they are published on the official website of the Council of the Judiciary. When it comes to the open character of deliberations, we need to become aware that during the deliberations, which are broadcast, the reference documents on the personalities of candidates are submitted. So it's not only about open deliberations, but also about open evaluation of candidates. We get some signals from judges that such written evaluations are constitute a breach to their personal and sensitive data, as they contain some personal details with regard to the date of birth, marks and grades from their judge exams. So we think that the transparency and open character of such deliberations is a higher value in the entire process. Additionally, all resolutions should be posted on the website and the public information bulletin, which was not the case. All activities should be confirmed with the written reports, which are archived, and it is also kept for records, and they should be open for all members and all participants of the proceeding. They so participants of procedure can make an appointment and can obtain an access to the documentation. The judges do not use this possibility too often, as they are not aware there is such a new solution for them. Another element of transparency is the multitude of entities which could participate in the competition. So this is the competition committee managing the entire competition process, but this is not full information, because in the meantime we obtain standpoints and opinions of many external entities. These are presidents of courts hiring such judges' opinions from some units, hiring these people opinions of collegial courts. And here, an important remark that members of college, these are representatives of different courts from a given region, from a given district. So a broad platform for exchanging information and a rich source of information on the functioning of a given environment. We can refer to the Ministry of Justice in any case. The Minister of Justice has such competence, which is not used too often, but we also obtain some opinions from the corporate world. So each candidate applying for the function of a judge, performing a legal profession, and is a member of some professional association, their professional corporation, let's say, the representative of such a corporation should be invited to the meeting of recruiters, let's say, and they can express their opinion. Some professional associations already use this possibility, but they have such a practical possibility to participate in the competition proceedings. When it comes to guaranteeing independence of judges who are elected by the council, the truth is that we have no tools in order to inspect or to evaluate how a given judge performs their duties. And here, with reference to what Professor said, our evaluation is related to competition and at a given moment of their professional careers, but it is very difficult to guarantee the manner how such a person will perform their professional duties because we have no personal or institutional relationships, and we cannot affect the way how the person will perform their duties in location A or B. And I'd like to refer to a short exchange of views. So whether the National Council of the Judiciary is a new council or not. I don't know if you are aware and if you have this information, but the National Council of the Judiciary is an institution which is founded within some factual framework. It means that apart from 25 members of the National Council of the Judiciary, we have some employees and we have an office over almost 80 people who are performing their duties, some of them for a dozen of years in the same institution. So we have something that we can call the institutional memory. We have our archives and a huge, large database with regard to previous proceedings and matters being decided by the council, and a professional standard which can be evaluated, but it is how it worked, is to use this database. So anytime we're dealing with any new problem, the members of the council establish what has been done by the council before. Of course, we take a different decision. Sometimes we modify the decision, but we do not neglect the records and the institutional memory that we have. We're using the same location. We have the same people, the same human resources, the same intellectual resources as previous councils. And in that respect, I think that we cannot talk about any other newly born institution. Thank you very much for this comment and for your support when it comes to this name. Ladies and gentlemen, it's not only about a body which takes place in a given structure. This is a constitutional authority. This is the National Council of the Judiciary. The fact that some principles of the Act on the National Council of the Judiciary have been amended at some point, it doesn't mean that anything new was created. So this institutional continuity, but also the continuity when it comes to the legacy of the previous terms in office, it is this tradition is continued. But once again, let me go back to this topic regarding the independence of judges working for the European Court of Justice. We've been talking about standards created and applied by the Tribunal when it comes to the evaluation of specific solutions adopted by the member states. Going back to this topic, these judges performing judicial review, do they present and demonstrate the very same standards? I will go back to Professor Szymanek and then to Professor Gontarski. So I will maybe simplify this question. I will quote the regulation, Article 252, Section 2 of the Treaty on the Functioning of the European Union. The task of the General Ombudsman is to present in a totally unbiased manner justified opinion which, in line with the statutes of the Tribunal, require their engagement. This is a reference to the Ombudsman and Article 19, Section 2, phrase 3, that judges and ombudsmen of the European Court of Justice and are selected among people with unquestionable independence. So these are the principles. Could you refer to them? When it comes to the normative layer of the principles of law, laying foundations for the function of the judge or the ombudsman in the infrastructure of the EU courts, we have not only European Court of Justice but also other courts. It reflects the regulations which are applicable in the majority of member states, constitutional member states. It was one of the elements of this shared political culture that we've been talking a lot for many occasions, which laid foundations to the European Union and its construction. From the time of the Portuguese mother, with this method of small steps, the European Court of Justice started to exegete the definition of an independence court with all the attributes of an European judge. We can observe a kind of dichotomy. On the one hand, there is some standards which are addressed to member states of the EU, but let me add that to some, they are addressed more frequently than to others. Let me quote that in some countries the legal culture is higher. Let me quote it, so the standards are different. In some other countries the culture is lower, and these countries should become more civilized. But there is an imbalance and some discrepancy in this the application of these standards. So the EU judges and domestic court judges do not have the same obligations. On the one hand, the European Court of Justice, especially in the matters regarding Romania, Bulgaria, and Poland, they tell that a stigma of independence of the EU judge is to separate them from the executive power, and at the same time we know that the appointment of the European Court of Justice judges is made upon the decisions made by the member states' government. So if we take a look at the composition of judges of the European Court of Justice, there is no single procedure. It is just a mechanism of discussion and of selecting some people who perform some high functions in the executive institutions. Judge from the European Court of Justice very often at the same time as a minister in one of the member states. So we have such examples which are visible in the majority of countries. A Spanish judge, for example, a multi-annual and an active participant, a member of a party, and also an employee of one of the departments of state administration, a judge from Denmark and from the majority of the EU states, if we follow their biograms and the mechanism of appointment of all these people for the European Court of Justice, we would find out that these judges, they do not comply with the EU standard of the judge independence, both from the perspective of their so-called professional career, because the majority of them are former ministers or some high-profile administrative officers, and very rarely we are dealing with an authentic court judge who's promoted to the European Court of Justice. And on the other hand, we do not have all these components which provide for what dear judge said before, so the transparency of the procedure, the fact that what is the function of the European Council of the National Council of the Judiciary? We know what is the mechanism that X, Y, and Z is appointed as a judge or not. And at the end, let me add before I stop, another element which makes it evident how different are standards. So the judge will confirm that each candidate for a judge in Poland can appeal from the decision made by the National Council of the Judiciary. And when it comes to the European Court of Justice, there is no appeal procedure from a negative decision. So this is another element showing that on one hand, this is a transactional mechanism of appointment of judges of the European Court of Justice, and at the same time, we have restrictive standards which should be complied with by all national courts judges who are called EU judges. So this is a flagrant example of lack of the procedure to appeal, which shows who complies with the standard of independence.
To adwocem poproszę pani sędzia.
Thank you. Thank you very much for that. In a minute, Professor Gontarski. Now, sędzia Krzysztofik, Dr. Krzysztofik. Like all the participants have the right to appeal to the Supreme Court. And for some time, there has been the praxis applied by the National Council, along which the resolutions of the Council regarding the competition process and those, particularly those repealing the resolutions of National Council, are made available to all courts. So regardless of the fact that the Supreme Court being able to place the resolution on its website so that it be available publicly, also the National Council on its own initiative makes the text of the resolutions available anonymized so that knowledge is spread among judges about how the Council chooses its criteria and how it acts in practical situations and practical individual competitions, and how the criteria and the procedure are assessed by the Supreme Court, whether it supports the assessment of the Council or not. So it seems to me that such an extended supervision, like Ms. Gołkowska mentioned, guarantees higher transparency and higher standards in general. And let's go back to the standard, the strand of independence of judges. Professor, how would you confirm, how would you comment, do these judges meet the standards that they establish? Where there is a complaint of the Commission, where it's enough for the judge to have been appointed by the President of the Republic of Poland based on the resolution of the National Council of the Judiciary formed based on the Act of Law, the amended Act of Law on the National Council of the Judiciary, and then it assumes that It was so in the case of the chamber, but when we're talking about the European letters, then it's not enough. Then you need to look at the in concreto text. I don't know if we mentioned the Wiseman committees of Article 255 of the Treaty on the functioning of the EU, because these Wisemen are appointed by member states after, based on the opinion of a committee. Such a committee, based on the committee on the Article 255 of the Treaty on the Functioning of the European Union among the members of the national Supreme Courts and jurists of accepted competencies, while member states are not bound by this opinion but have to consider the opinion in general. And we've seen cases where a negative opinion of the committee caused a person not to become a judge of the Court of Justice. In my opinion, the judges of the Court of Justice, since I cannot prove that they deliver the rulings at the instruction of any kind of other power, political power, then I would say that they are they do meet the criterion. But if we're talking about the assignment, that is the condition applied in the rulings on a request of the Commission, they do not meet that one. So there's this dichotomy, which is not clear why there's this dichotomy. In the current structure of the judiciary in the EU, the Court of Justice and the judges are seen as a super judge, super arbiter. How would you define Marcin Wielec? Well, let's put things in order. First, there's the Court of Justice of the European Union, is the highest institution in the European Judiciary. That has two consequences. There's how it functions and how it interprets law. The remit of competencies, the first thing, is clear, because that's what the court is to do. If we have to divorce, we go to this and that court. We have a civil contract, we go to a different one. And I think Article 19, if I'm not mistaken, of the Treaty on the European Union defines the remit of the Court of Justice. And according to that article, the Court of Justice rules according to the treaties, giving the frameworks of the European Union, which is clear. And these treaties are international agreements, aren't they? There are parties to these agreements. There are provisions to these agreements, like in the case of every contract. For example, we strike an agreement with you. We want to sell a car. We have a contract. We know what the contract says. I gave you the money, you gave me the car keys. We have no doubts about this agreement, this contract. Right, done and dusted. Now we have this super judge who says, no, you did not only agree to sell a car, but also to sell your washing machine, your bicycle, etc., etc. And so it says, we actually went outside the framework of the contract, and we say, no, we did not. We just struck a contract, we concluded a contract. And this is the scheme. I hope that this simple example shows you the model of how the Court of Justice of the European Union works. Court of Justice, which should have its competency and work within its remit as granted by the treaties. Otherwise, it doesn't make sense. These treaties are international agreements, These are contracts, agreements. You need to live up to your contracts. If parties have a contract, an agreement, if member states have second thoughts and think we need to change something, then we have a procedure to amend treaties. But this has never happened and will not happen, looking at things as they are. Pax servanta rule says that we need to stick to the agreement once it's been concluded. While we see in the EU that the Court of Justice takes the floor in issues it has no competency for, in issues the member states did not agree for. And this is the analogy. We did not agree to sell a washing machine. And somebody tells us, yes, but the contract says something completely different. The Court of Justice then is this super judge, super referee, but also subjectively, because objectively it has no grounds for, there are no grounds for saying that it has such competencies, which is absurd, because treaties of the Court of Justice are seen as a some kind of case law, a final decision, which, again, bears the risk of the EU receiving additional competencies because, again, we are beyond the framework. Now, talking about the organization of the judiciary, this is precisely the case. This is the object of the contract, which I did not agree about. The Protocol 30 between Poland and the UK does impact the functioning of the Court of Justice of the EU and these relationships. I don't want to go into the details because, again, we're going to stir up a legal discussion, which is something we don't want in this place, but it completely changes the functioning and the mandate of the Court of Justice I just told you about. The mandate is easy. Interpretation should be easy, but at all times somebody tries to go beyond that, beyond the framework. Could you please comment? Right, the Court of Justice has this mechanism which it applies every time when it goes beyond its own competencies. Then it refers to the spirit and aim of the treaty. This is the element of the final interpretation by the Court of Justice when it sees no legal basis for its decision, and it's not based in Article 255 of the Treaty on the Functioning of the European Union, which makes it possible to apply its rulings under certain procedures that are not based in the treaties, but allowance for additional solutions with the participation of the Court of Justice. They apply this rule, which took place in the Maastricht ruling. But it's along the lines that the courts can deliver rulings, but within the remit granted by the member states. Now, referring to this answer, let me pick up on two issues. One is the national judge and EU judge. The national judge is a EU judge at the same time automatically? A brief answer from Ms. Krzysztofik, please. Well, a brief answer to such a difficult question is impossible. Unfortunately, we have very limited times. Well, ladies and gentlemen, generally every national court that rules under EU law becomes an EU court, and at that point it brings up particular interest on the part of the European Union. There is now talk of an EU status, European status of a national court. This has been combined with the effectiveness of law rule. So every judge, national judge, has to guarantee the effective application of the EU law, which is applied whenever there are any doubts about the norms of the EU law. And at that point, the national court becomes an EU court and has at its disposal the remit stemming from the rule of application of the national law in the first place. And it seems so obvious that as we have national law, we have European law. There is a collision in terms of the competencies of the European Union. All these rules apply in the competencies of the European Union, but we end up in a paradoxical situation. For example, in the Romanian system, when the Court of Justice says that the National Court is so deeply obliged to apply European law that it can refuse to apply rulings by the Supreme Court, the Constitutional Court. It took place also in the Filipiak cases and others, but in this ruling regarding Romania, it's clearly stated that the National Court has its exclusive competency to decide which legal norm it applies in its proceedings. Thank you. Thank you. Thank you very much. Following along these lines, it would be interesting to pick up another issue. In the context of the remarks, it would be worthwhile to wonder about the relationship between the EU law and national law in the context of the Polish matters, and wonder whether, in the first place, the EU law should be applied or national law should be applied, and whether the judge is authorized to go around the Polish law if they come to the conclusion that the Polish law is not aligned with the European law. Such a competency, applying law and delivering justice on behalf of the Polish state, could be delegated to the judge or not. And has this issue been decided upon definitely in the recent months and years? In the first place, I would like everybody among you, ladies and gentlemen, to briefly answer this issue, referring to rulings, recent rulings. May I ask Mr. Wielec in the first place, then Mr. Kontarski? Well, we have little time, so yes, please be brief. I'm traditional, and I am a believer that the Polish law should be first and the European law is subsidiary to it. I have no more to say. Professor, what is your opinion? My opinion is the following: that the EU law should be more important than national law. And if we look into the treaties, they exclude the primary character of the EU law, because the treaty says that the declaration for the Lisbon Treaty is not part of the treaty acquis. But the Court of Justice has been interpreting about the primary character of the EU law, but that is just their interpretation. The Luxembourg court, with no grounds in the treaties then or now, used to claim that the judge did not need to wait for the ruling of the Constitutional Court or legislator. That is, it applied a primary character to the EU law before the national law. Until Lisbon, there were doubts. After Lisbon, there are no doubts anymore, because that rule was included in Article 6, but it was not adopted. I compared the frameworks of the Constitution to the American Constitution, and there is also this rule which does decide upon the matter of the U.S. being a state. Was not adopted. The rulings of the Council of State, the French Council of State, and others show that there is no primary character of the EU law, although the Court of Justice stands at a different position. Mr. Szymanek, please. Constitutional Court of the 7th of November last year Back then, the court said that as long as the EU institutions, including the Court of Justice of the European Union, function in a space on which a member state, in this case the Republic of Poland, expressed their agreement by delegating their competencies based in the Constitution in Article 90. So far, when there is a touch point of the national law and the EU law, then, in the context of the Polish institution, that is the Article 9 and the relationship with international law, and taken into account the text of the treaties and loyal cooperation rule, then treaties should be applied. The problem is only that in recent years we have clearly seen that judges, particularly in the Court of Justice of the European Union, by reading the treaties, reject the method being an way to understand the treaty and assume that the Court of Justice becomes an act of willingness, which completely changes the point of view of the European judge, because that European judge starts creating legal norms wherever there is space, and space is in the spirit and the aim of the treaty. And K3/21 says clearly that what was negotiated does reflect the current stage of development of the European Union. That's precisely what it says. At the same time, it says that the treaty signed in Athens in 2003 reflects that stage. The problem arises when the mechanisms of judicializing the EU start when the process enters another stage. A stage that is not anchored in treaties on the one hand, and is not anchored in delegating competencies of the member states to international community. And in that case, the rule is clear. Paradigm of Article 8 is applicable. That is, the highest act of law in Poland is the Constitution. And, well, on a final note, this is not a new issue. It's not the case that in 2015 we created the problem of a clash between the national law and the European law, and these issues arise since the 60s. The case of Solange, for example, proceedings, or the recent ruling of the French National Council of the State, and others. All these demonstrate that this is an old issue resurfacing, and one of the French constitutionalists in his book about the EU law, I think, was very pertinent in his diagnosis, along the lines that the clash between the constitutional and European law can be seen from 2 points of view, namely the frog, that is seeing the closest pieces of grass, which is the Grundgesetz, or you can see the perspective
owej przypowiastce jest oczywiście
of the stork. And that stork is the European Union, the treaties, and the Court of Justice of the European Union. And he said that the stork and the frog cannot come to an agreement. But unfortunately, this illustration also shows us, very sadly, that in a clash between a stork and a frog, the fate of the frog is unfortunately quite clear. Thank you. Thank you very much. Dr. Krzysztofik wanted to take the floor very briefly.
With regard to what has been just said, I'm not an expert in constitution law. I'm in the EU, expert in the EU law, so I take a totally different perspective on the EU legislation. But no matter what is my interest in the European Union, it is important to have two extremes. On the one hand, we have the European Court of Justice protecting the EU law and interpreting the EU law and supporting the member states in the application of the EU legislation. And on the other, they need to be the European Court of Justice protecting the competence, the exclusive competence of member states. So when we are dealing with colliding principles of law, the exclusive competence of a member states against the the EU law, the latter should prevail. And now let me refer to the ruling of the European Court of Justice, which during last year on many occasions dealt with the relationship between the EU and domestic law. There were some decisions, some rulings issued, and the Polish Constitutional Tribunal declared that within the scope of the European Court of Justice, the Court of Justice, and to the extent where they do not respect the decision of the Polish Constitutional Court, it allows to create the competence, and so EU regulations interpreted in this way are not in line with the Polish Constitution. And just to wrap up this session, the rulings of the European Court of Justice are applicable. Any questions? Thank you very much.
Proszę Państwa, teraz będziemy mieć...
Ladies and gentlemen, now we will have a short presentation of an MP to the European Parliament. It will be Jorge Buxade, a lawyer and public prosecutor in Spain. And in the past, he represented the Spanish state in the dispute with regard to the independence of Catalan. And now he will have a short presentation. Afterward, we will move over to the discussion.
La independencia del Poder Judicial de ilegítimas intromisiones del Ejecutivo, de los parlamentos o de organizaciones y personas privadas es uno de los objetivos principales que persiguen los sistemas jurídicos de los Estados miembros a través de los diferentes mecanismos previstos en sus propias legislaciones nacionales. En el caso del nombramiento de los jueces que han de asumir el gobierno del Poder Judicial de cada Estado miembro, existen diferentes sistemas según las particularidades territoriales, culturales o la historia jurídica de cada nación. Así, en las diferentes legislaciones podemos distinguir 4 modelos básicos: el nombramiento por parte de instituciones políticas, por los propios jueces, por un consejo judicial que puede incluir miembros que no formen parte de la carrera judicial, o la selección a través de un sistema electoral. En cualquier caso, lo que sabemos todos es que la Unión Europea carece de competencias para decidir qué sistema de autoorganización judicial ha de elegir cada Estado. Bueno, cuando digo todos me refiero a todos los que nos mantenemos en el respeto a los tratados, el sentido común y el amor a nuestras patrias. En el caso de mi país, España, el órgano de gobierno del Poder Judicial es el Consejo General del Poder Judicial, que está compuesto por un presidente, que preside también el Tribunal Supremo, y 20 vocales. El caso español se enmarcaría dentro de la primera configuración o el primer modelo, ya que es el Parlamento quien elige a los 20 vocales, 12 entre jueces y magistrados y 8 entre juristas de reconocida competencia. El presidente lo elegiría los vocales entre los candidatos que reúnan los requisitos que recoge la propia ley orgánica del Poder Judicial. Este sistema en sí mismo no constituye en modo alguno una injerencia ilegítima en el Poder Judicial. Sin embargo, Vox defiende que los 12 jueces, como dice el texto de la Constitución, sean elegidos por los propios jueces a través de un sistema que respete el mérito y la capacidad. Sin embargo, en la realidad, Partido Popular y Partido Socialista han pactado durante 33 años los jueces que van a ser nombrados por el Parlamento, atendiendo a sus intereses de partido, particulares o ideológicos. Esta forma de elegir los jueces que han establecido populares y socialistas está más cerca de un Estado de partidos que de un Estado de derecho. Y sin embargo puede verse como una injerencia en el Poder Judicial por parte ya no del Gobierno o del Parlamento, sino de los partidos que no representan la soberanía de la nación española. Pero en el caso de España, como la línea ideológica de los sucesivos gobiernos populares y socialistas está en línea con los objetivos federalistas de las instituciones europeas, no genera ni suspicacias ni rechazo, como sí sucede en los casos de Polonia o Hungría, donde abiertamente se está intentando perjudicar a unos gobiernos democráticamente elegidos. El Tribunal de Justicia de la Unión considera que el concepto de independencia judicial es un concepto autónomo del derecho de la Unión y que supone que los jueces han de ser independientes y estar protegidos frente a injerencias externas que puedan poner en peligro la independencia de sus sentencias. Para ello se utiliza como base el artículo 19.1 del Tratado de la Unión, en el que se establece que los Estados miembros establecerán las vías de recurso necesarias para garantizar la tutela judicial efectiva en los ámbitos cubiertos por el derecho de la Unión. Por otro lado, la Carta de los Derechos Fundamentales de la Unión Europea establece en su artículo 47 el derecho a la tutela judicial efectiva y a un juez imparcial. Pero de ahí no se puede inferir la competencia de la Unión ni del Tribunal de Justicia de la Unión para indicar coactivamente a los Estados miembros cómo deben configurar sus sistemas judiciales, y menos cuando hay intereses políticos de otras naciones en que esos cambios y esa presión sucedan. En realidad es una interpretación abusiva del tratado, que pretende convertir la jurisprudencia del Tribunal de Justicia en una norma vinculante para los Estados miembros, por encima de sus parlamentos. La única competencia atribuible al Tribunal Europeo en este sentido sería la de garantizar exclusivamente en los ámbitos cubiertos por el derecho de la Unión que se produce una tutela judicial efectiva. A nivel nacional, que es donde deben producirse estas conversaciones y donde no deben existir injerencias violentas de países aliados para que se produzcan cambios normativos, mi partido defiende que los miembros del Consejo General del Poder Judicial sean elegidos por los jueces, sin la intervención de los partidos, ya que se producen constantemente intentos de interferir en la justicia por parte de los partidos que han ostentado el poder desde que empezó el período democrático en España. Esta intromisión ilegítima de los partidos es rechazada por Vox, pero aún así reclamamos el derecho exclusivo de los españoles a resolver por nosotros mismos este problema o esta injusticia, sin interferencias y amenazas por parte de las instituciones de la Unión Europea. La Europa que queremos es una Europa, en primer lugar, respetuosa con los propios tratados y una Europa respetuosa con las tradiciones jurídicas y los principios de organización social, política, económica y cultural de cada Estado-nación. Gracias a todos y perdonen por no poder estar presencialmente con ustedes a lo largo de estas jornadas. Muchísimas gracias.
Witam Państwa, Tomasz Pietryga.
Welcome, ladies and gentlemen. Welcome to the journalists panel. The editor, Bronisław Wilczstein, Rafał Ziemkiewicz, and Adrian Stanowski. Before we start, the topic of our panel today is the evolution of the entire system, evaluation of judicial appointment models in the European Union. I think we will provide you with some external journalist perspective. But before we do it, let me start with a short introduction. Part of what you've said is the area of my expertise. I'm talking about the National Council of the Judiciary, and I'd like to tell a few words about the evolution of this National Council of the Judiciary from a totally different perspective. What was said by Judge Dalkowska, it presented in details how the National Council of the Judiciary was functioning before and how it was set up. When reading the protocols from the round table, it was defined in a beautiful way what should be the role of the National Council of the Judiciary. So it's not a self-government of judges, but as it was presented by Legardowski, that this is a hybrid authority based on the tripartite division of power. And through this prism, the council was founded as a hybrid body. It was a great achievement, the appointment of this council, because it is an element of democratic country. We had a similar council in the intra-war period, but this beautiful idea failed in the end. Out of 26 members, 18 of them were judges with the Polish People's Party, Communist Party IDs. Two of them were active during the martial law. Another member, was the head of the confession inspection office, so not an infamous person, let me put it like that. And these were people who appointed several thousands of people and appointed them as judges. I've been analyzing the protocols, how the verification before the National Council of the Judiciary was carried out. So how these communist judges were appointed at the time of Free Poland. There was no criterion to examine their communist past. So it appeared that, for example, the Professor Adam Strzembosz, a member of Solidarity movement, was appointed as a judge, and Józef Iwulski, who sentenced people, got his appointment immediately. And that was the face of this council. Of course, it evolved over the time, and it adopted its corporation nature. It was a kind of an institution for a group of people, for a group of judges who appointed themselves and elected themselves from their environment, which raised obstacles from the younger judges who were not represented. And the year 2018 was a breakthrough year, because the principles of appointment of judges has been changed. But in my opinion, it went one step too far. At the beginning, in 2015, there was a fragile compromise between the environment of the judges and the political power. So, especially young generations wanted the National Council of the Judiciary to be reformed, but this reform was radical, and that caused they didn't agree for the reform, and that led to a conflict. So this is the historical background. And now let me ask my colleague, Bronisław Wildstein, how do you perceive the evolution of the council? Oh, and editor Biedroń joined us. Great to. Now it's okay. Maybe I will leave this question. Oh no, or maybe I will tackle it. You said that there were beautiful ideas behind the idea of this reform, but it failed. There is always a human factor. If you give the best mechanism to people with bad intentions, they will distort it. But let me remind you, I'm not sure whether it was such a great achievement at the round table, because it was accepted that judges will not be dismissed based on political promises, but they should be first and foremost appointed in line with the principles of law in order to prevent them from being dismissed. Because if you appoint them against these principles and then you will freeze them there, it will lead to the situation we had. It was not only a matter of communist judges who had different requirements. These were judges whose records were cleared by the martial law, because during the solidarity movement time, there was the solidarity of judges in the 80s, but the majority of all these judges, they lost their place in their profession. Some of them came back to it, but some not. So there was a corporate body which was not sure of itself. So even more, they took care of their corporate interests, and they wanted to defend their position. I would not agree that this reform was too far-reaching. We can discuss the political errors, but I don't want to go into too much details here. This reform was not attacked and was not criticized based on this premise. It was attacked because of its fundaments. The problem we are experiencing in Poland overlap with a broader problem, and Professor Szymaniak mentioned that. The fact that the role of a judge has radically increased in the 21st century. Why? For many reasons. One of fundamental reasons was that there is a dominant ideology whose funded on the imagination. This is the emancipation ideology, which on the one hand dismantles the traditional cultural order in the name of a well-defined utopia. So the traditional cultural order of the Western Europe is treated as the ladder thanks to which we climbed the level we are now. But in the more radical version, it is treated as the world of limitation, of superstitions, of patriarchy, and the world from which we should emancipate. And the European Union closes this gap, starting from the end of the 80s and formally starting from the Maastricht Treaty. It became the vehicle of this new ideology. This new ideology refer to the human rights, and they are treated in a very dynamic manner. And that may stir some doubts. The legal system was supposed to be the structure of something certain, of certainty for people functioning within a given social or political system. That was supposed to be the point of support. And if it happens that everything depends on the interpretation, they become a tool to the stronger. We live within the model called liberal democracy. It aims at limiting democracy as such. Such older people like myself, we can remember the people's democracy, Demokracja Ludowa in Polish. It was the pleonasm functioning the communist systems. So there were such adjective-based wordings. So this is a democracy limited by a wide scope of rights. This corporation is an element of oligarchy. This liberal democracy system is aiming at oligarchy. It's a network-based system of dominant centers, large corporate bodies, and big business like legal firms, media, opinion-making institutions, and so on and so forth. And their tool is law understood in a specific manner. The law that should regulate all aspects. We live in hypotrophy of law. We are taught that everything would be decided by law. Of course, it's not possible for everything to be decided by law. So if the law does not apply, we multiply it. And the law serves for different purposes than its initial purpose. And systems which are that creates a system which is more flexible. I know I'm taking too much of your time. I'd like to present a broader perspective of all these phenomena in order to show you how what is going on in Poland is inscribed in a broader system and a broader process, the one that we are describing here. So this attempt of the European Court of Justice to grab broader competence and far-reaching competence is only an element of that, but it is important that behind it, this facade of European utopia, what happens? We've heard in the description of how different functions operate in different states, we've heard that in the countries like Germany or France, these systems are more involve more politics. maybe we should, I don't want to question that. Maybe it's good that citizens can affect the law, the judiciary through their representatives. But at the same time, we see that when it comes to all these states and legal systems, the European Court of Justice takes absolutely no decision. There are some individual attempts to attack them, but at the end of the day, the European Court of Justice refrains itself from many actions. So this is about clear mechanisms of the stronger wins. Poland will be disciplined. The new authorities do not fall within the new liberal democracy structures. They're not accepted by the European establishment. So Poland is being disciplined, and this is how it is. And now over to Rafał Ziemkiewicz.
Na pewno mnie słychać? Pozwoliłem sobie
Are you sure you can hear me? I wanted to take the floor because we put things the other way around. I think we should have started instead of current affairs, rather, like Bronisław said, we should start with the beginning of the process that we're dealing with. This is the first time for me to be in a comfortable situation, this a never-ending discussion, where I can present an argumentation with a number of rules. Sorry, that these number of rules with cases have been presented. So I don't have to go back to that. Indeed, those who seem to be defending the rule of law are doing the opposite. This is a non-content related rebellion just against a certain political group. It's like a Polish Luhansk. A state within a state which announced its independence, although it's not like the Luhansk Oblast, which announced its independence and called on the Red Army for support. It's a corporate state, which at the point where the corporate interest is at risk due to measures taken by the state, it's called on the European Union, hoping that the EU will impose the privilege, the corporate privilege, to be kept. Where did that privilege come from in the first place? Well, you would have to go back to the round table deal. What was agreed on back then, we don't know, because it was just a spoken agreement. It was never written down. You won't find the round table agreement in archives, and yet we know that it was concluded. And we know from Giedroyć, who heard from Mazowiecki, and who published it, that the condition on the agreement on the transfer of power by communists at the round table was
Giedroyciowi możemy zaufać, kiedy on relacjonuje, że w rozmowie
impunity, not being punished for their crimes, and it was, that was the deal struck, and it had to be kept, is what the participants of the red table, of the round table said. So there was a certain safety valve, so that this impunity be kept, even if something happened on the social part of the deal, and if that social part wanted to break that rule and start punish the communists. And that's how the entire system was formed so that communists could not be punished, which is demonstrated by the Kiszczak, the Wujek proceedings, cases, and a very spectacular example being the case of the December 1980 court proceedings, which took 15 years and ended only because Jaruzelski died. If it hadn't been for that, it would continue to this day, because the judges who led the process called on witnesses all the participants of the 1980s events, although the aim was to so thousands of people who were called as witnesses, although the aim of the proceedings was to conclude who gave the order to open fire. So a state within a state was created on purpose to guard the best interest of the group transferring the power. And that state within the state started to be guided by its interests, particular interests, and then being at risk, it called for help. So why is there no grounds to bring into question the legal character of the formation of the National Council, KRS? And even if there was any grounds for its legality, then they have no right to bring into question the recommendations of judges appointed by the KRS after 2016 to rule. It makes no sense in the light of the Polish Constitutional Court and the Court of Justice, all the three between 2015. It was confirmed that if the judge, even if the body appointing him was not in line with the law, could not be brought into question his legal status. And but calling the judges new judges is actually bringing into question their capacities. We have seen such cases. And judges do not want to rule with, deliver rulings with judges that were appointed after 2016. So, why is he getting such strong support from the European Union? Well, that's yet another issue that has to be raised. That is, there's a craze in the European Union, craze for federalization. There's the obsession of building a federal state, not by bringing nation states closer together, rather by building a central government. It's an idea to build a new Yugoslavia, an enormous Yugoslavia. Everybody knows how Yugoslavia ended. It's an idea to balkanize the entire European Union. It's a completely stupid plan led by madmen, and we have to oppose to that. And from that point of view, the Polish Luhansk, the Polish separatist state, lawyer state, found its protectors who came to the conclusion that it was a very comfortable situation, like Tsarina Catherine. Once came to the conclusion that the Magnet group who were at risk as a result of the reforms in Poland. So they turned towards this arena for protection, who was the guarantee of the cardinal rights. And the Targowica participants asked her for support. It might be an abused comparison, but I think it's very pertinent. Thank you very much. Thank you. Thank you. Adrian Stankowski now. The floor is yours. 1, 2, 3, testing. I'm afraid we need to go back in time even more than the round table. Because what we're dealing in is an element of a pressure apparatus, a pressure system. After the arrival of communist Tovarищ comrades to Warsaw, what was done was taking conscience away from judges. If a judge has no conscience, then no legal provision will defend us against such a judge. I have this experience of a district court in Warsaw and labor and social insurance department rejected an application of a mentally handicapped person to have a ex-office plenipotentiary in court. And that's, he did not infringe any legal provision because that's discretionary on his part, but such a judge is simply a rogue, simply put. And my editor colleague, Maciej Marosz, wrote this book, Resortowe Togi. It's worth reading because this is precisely the topic. Some of those Stalin times are still up to date. There was talk of Iwulski, a captain of the Secret Service of the communist times. His name was kept secret for 30 years in the so-called Z archive. He was delegated to the Supreme Court by the Secret Service. He's a very interesting, important person because he, quite up to recently, was president of the labor chamber and the Supreme Court. Unfortunately, he talked about the safety valve, the judiciary being a safety valve. So the safety valve of the safety valve was the labor chamber, because appeals to decisions of the KRS, Judiciary Council were looked into by the labor chamber, and the co-optation system for the mafia, compared to that, one might say, is fully transparent. Maybe they did not cut their thumbs, but other than that, it was entirely a similar process. And those judges, after the round table, started aspiring to become oligarchs, an aristocracy, one might say, referring to Confederation, the Targowica Confederation. And they lost their capacity to understand basic notions of law. For example, I always tell young journalism students to not think they are the fourth power. No, the fourth power is the public opinion. We are just at its services. The same goes for the judges. They forgot that the power of the Republic of Poland is the nation. We delegate judges to play the role of the judiciary power in our name, on our behalf, because a judge delivering a ruling delivers it in the name of the Republic of Poland. And I don't want to have to be ashamed of these rulings by judges who, on many occasions, really raise my hairs. The same goes for independence, judges' independence. This is an institution for the benefit of the judiciary, that is, the justice. While independence, judges' independence, is not an element of have a godly character of the judge, it's not an element of widened immunity of such a judge. It's a service that they pay, and it's worth reminding to the judges. I completely agree with Rafał and what he said about the judiciary, the judges' group of interest, the vested interest, particularly since for the last 7 years the discussion about the rule of law, and particularly its infringements, has been very similar to a aristocratic kind of party play, the facade. For 7 years I've been asking the representatives of opposition and journalists, lawyers, which article of the Constitution has been infringed. And I haven't heard an answer for the last 7 years. And since such an accusation is being articulated, then it would be nice to hear which provision is being infringed. I would like to hear some proof alongside the accusation, because you need to have some victim of this infringement. Maybe somebody is jailed for political reasons or lost their job. Where are those victims, those casualties? While it is being said that the reform of the judiciary is introduced, executed in a Jacobean way, but remember that those guys used to use guillotines, and I don't think that is the case for Poland. It doesn't seem so to me, or I might have overlooked something. If so, tell me. So there's the problem with the judiciary, mainly because we have a problem with an element of the judiciary, one that is difficult to regulate, because the judge does not have this small screw that can be easily scaled. And repairing those consciences, particularly by politicians, is a difficult process, and that will still take a lot of time. Thank you. Thank you very much. Can Mr. Biedroń hear us? Please, take the floor. Actually, we're not hearing you. Oh, now we can hear you, yes. So with great attention, this history that has been drawn of the issue was very interesting. The question is, where are we headed in Poland? We are headed towards not legal dualism anymore, because that's what we're dealing with in a situation where one or the other judge does not agree with this or that judge, this or that ruling, etc. Well, remember that the judge is just the mouth of justice and not justice as such. This dualism is slowly being transformed into an anarchy. It's a cancer of the status of judges being undermined by other judges, which is commonplace in Poland now. All this leads to a chaos in the system, because the rulings, the resolutions of the chambers are seen as invalid. But we have gone further. I remember when the representatives of the Justicia Association met at one table with politicians of civic platform and presented an act on redressing the rule of law. And that included throwing judges out of their jobs, their positions. I thought that was crazy. It would be discarded, but not in this case. So we then saw the amendments by the Senate, the higher chamber of the Parliament, and that included the resolutions of the disciplinary chamber to be seen as obsolete. It said that the disciplinary chamber members had to be fired with absolutely no appeal system. They would be banned from taking positions in the Supreme Court. As of today, they haven't discarded, but they will be back, I assure you of that. At the moment when the current opposition, comes back to power, they will definitely pay for the fact that they supported this group. They will have to repay that debt. If we have obvious infringement of the Constitution in a clear way, this is a song of the future. This is what this group of judges wants to see in the future. The opposition leader apparently said what he was going to do to the president of the Constitutional Court. The journalist asks Tusk a question, and the possible future prime minister, a serious person, ranking high in European structures, says that she has to be fired and says that he does not need any acts of law, that the person, that is the members of the National Council of the Judiciary, will be let out. Judges keep commenting on political issues. They are not impartial anymore. I looked at a tour of the Constitution today. There is this event where judges make a tour, also prosecutors meet with people and talk. Say, for example, that the Polish state prohibits abortion and say what they would do to go around legal provisions that they are supposed to guard. Today I saw Judge Tuleya, who, Gdańsk, I think, in an old t-shirt and denim trousers with, and he was a civic judge because he left the court and is now a civic judge. No, ladies and gentlemen, the judge has strong powers in the courtroom, and that's where his place is. Not at a festival, a youth festival. These situations are completely unacceptable in countries like Belgium, Netherlands, or Germany. That's unacceptable.
There are decisions of courts which are very controversial, which go behind that, which follow these rulings. We're dealing with a situation when the judge who wants to do bad to the public prosecutors, and they release drug dealers from prison, some unknown, and we cannot tell that these are bandits who were released by Judge Tuleya. The higher instance court criticizes on Judge Tuleya's judgment, and any aftermath, there's no problem. These people, and it's possible in politics because they became politicians, they will exercise the judicial power. They will grab this power in their hands, and for an average Polish citizens, no matter what is their political standpoint, it is dangerous. We are heading towards a rock, and hopefully our ship will survive. Thank you.
Teraz chyba lepiej, tak. Dziękuję bardzo. Ja chciałbym
This historical line, and with regard to what was said by the models of self-government of judicial councils. Now it got transposed to the level of the European Union. The politics plays the lead part here, not law. If I may. It's quite interesting because on the one hand, you've been talking about this need for balance and respect for representation of the citizens, and then he went to these shoes of bad politics. There is a bad politics as there are different ways of offering judgments. But talking about politics as something immoral is a blast to the morality that leads to a grotesque dimension. Do you remember some ideas? Technocrats, governments. There was one weekly, and we could read that best government, it should be the government made of experts, and so politicians are not needed. Of course, politicians are sometimes bad, and what Wojciech Biedroń said about scandalous behavior of the total opposition, we could go into details, but we're living at the times of fierce political conflict, and which are even greater, they didn't overlap with the fundamental cultural war we're observing now. In the European Union, it has been won by one party, but we didn't inscribe into that because in Poland, not the right people were appointed to as a government who fall within this ideology which is prevailing. So I'm listening such comments that this is hard to believe in France or in Germany or in the Netherlands, and I'm thinking maybe they don't take this form because the Germans, they do not refer to any external forces, nor the French or the Dutch. They do not intervene with the European Union. They do not ask for re-establishment of order in their home states. But the entire profession of judges, they ask for more and more prerogatives. It's not the problem which is limited to the European Union. For the last 2 years, I took a look at two specific court decisions. In France, there was one ruling, a famous story behind that of a farmer who was living near the border with Italy, and he helped illegal immigrants, and he helped many immigrants, illegal immigrants who were placed in France. He was sentenced, and he appealed to the European Court of Justice, and his sentence was deleted, was cancelled, and he referred to the idea of brotherhood, because this is in the French credo that there is equality, independence, and brotherhood. So that was just striking the balance between powers. And we're talking about Poland, where this conflict is fierce and it is supported by external centers. And at the same time, very often we forget that this is a reflection of deeper cultural war, where the majority of corporations of judges are on one specific side because that offers them a share of powers. So if they interpret laws in constructive manner, as we've heard in case of the European Court of Justice, but the Constitutional Tribunal also reveals the same. It's nothing weird, that it's a highly attractive role for them. Thank you very much. 4 minutes left for this panel, so I would like to ask you for additional 1 minute. You have 3 minutes to conclude and wrap up this session. Rafał Ziemkiewicz. Two very dangerous phenomena, which are the most important in this discussion. First and foremost, if you think that my comparison to Lugansk Republic is too harsh, too drastic, so this is about separatist movement. If we talk about something like National Council of the Judiciary, if we try to call the Council of the Judiciary is called Julia Przyłębska's council, and then the third, the most important person in the country, the the speaker of the same, tells that the president is not duly elected because up to him the election were rigged in Poland. Maybe they were not rigged, but they were illegal for this or another purpose. So it's a high level of absurd when people representing institutions responsible for standing on guard of the Polish law and order negate such institutions, and they are supported unconditionally by the European Union institutions, sometimes in a grotesque manner. There is a series of resolutions taken by the European Parliament against things which never happened. Mr. Biedroń, Wiader Biedroń. Yeah, you need to live with this burden that there are some LGBT-free zones in Poland, and he cannot enter a restaurant because of this as a homosexual, and Poland is punished for that. And he says that the Law and Justice Party wants to put a ban on sexual education at schools, or they want to put a ban on divorce. So why is it happening? These fractions, which are leftist, are engaged heavily in the fight against Poland. Another thing that falls within the plan of disrupting Poland, we are the first on the fork to pave the way for what Martin Schulz called United States of Europe. And the third thing, these are some personal connections which play an important role. We're not talking about the majority in the corporation of judges. We talk about some establishment of judges, 7 or 10,000 judges from Poland and representatives of other legal professions. So let me put as an example one famous lawyer and professor who is the son of a communist official, and he had a lot of colleagues abroad because he studied abroad. So he had a lawsuit for defamation because somebody accused him of selling some faulty products, and he spread the information that he's a martyr, that he's being repressed for his opinions and views, and the European Parliament is functioning based on the very same, in the very same manner. And the European Commission tries the same. So based on the information from a newspaper. So some comment of a private person, some important decisions against the entire state are made. Thank you very much. And once again about disinformation, because from the very start of this reform of the judiciary, we had to deal with high rate of disinformation. I would call it the state of lack of any shame. The penal law specialist, I don't know if you can remember Renata Berger's tapes, and there was a question about these tapes, and it was said that this is the crime of political corruption. A student, the second year students be should be dismissed from the university for such an answer. So there is no shame, and that interferes the act with violation of this principles of tripartite division. So it was creation of law, and it was the Constitutional Tribunal made the right decision to cancel it. For many years, I'm fighting for separation of the world of journalism and politics and law. And here we have the whole series of such behaviors with regard to the legal matters, people wearing judges' uniforms, they express their views. It's good people have their political views, but if these views affect the rulings, and I'm talking about the ruling issued by the Constitutional Tribunal, with regard to, so you will have an opportunity to read the justification for that. The High Tribunal, and of course the President Rzepliński was the head of the tribunal at the time, that the legislative power has left a trap for the tribunal. Of course, we're living in a free country, and you can think that, but there is no legal argumentation behind that, no justification. And unfortunately, all that leads to deterioration of the fundamental principles, and that constitutes a breach to the public arrangement, because the Constitutional Tribunal, it's a social agreement that this or that guy wearing a kind of uniform, they decide on our life. Unfortunately, this social contract has been broken with the lack of trust to judges. Thank you very much. And as last but not least, point out a complete lack of reality among judges and lack of awareness about the reality. These are all European judges. These are not judges of the Republic of Poland. They stress that they are European judges, and of course there is the supremacy of the European law over the Polish constitution. And I'm having Andrzej Rzepliński on my mind and his statement, the General Assembly of the Constitutional Tribunal, the 4th of April 2012, and in 4 or 5 sentences he reminds some rulings, and he reminds that the Constitution is the highest act of law in Poland, and he also writes about the European Court of Justice, Professor Rzepliński, 10 years ago, stating that such an understanding of the competence of a tribunal is that the tribunal can examine the EU regulations, so it does not. So he explains that the tribunals are not competing one with another because their scope of competence is different. So these are words of Professor Rzepliński, spoken 10 years ago before the General Assembly of other judges. And this European behavior becomes a parody of the judiciary when the judges quote the rulings of the European Court of Justice, which are against the constitutional authority based in Poland. Because in part of these judgments, European Court in Poland, so we're dealing with a regression for part questions, something which should be unquestionable. And this is not only a citizen judge, but also European judge. It's a symbol of this regression. So this is just a gate to hell of legal uncertainty, and we're heading into this direction. Thank you very much. Do you have Bronisław Wilczstein, would you like to add something? The answer lies in politics. It's a problem to politicians. The problem is fundamental. We can see an exceptional situation because the war, because of the war in Ukraine. So there were some European forces that decided to fight against the governing majority in Poland and impose a muzzle. Now the situation has changed. You all know this is the EU interference and the US interference, so an imbalance of and disruption in the leadership exerted by the Germans and the French. So the reforms should be adopted. We should restore the judiciary to its functions, but we need to become aware that it's not exclusively a Polish problem. Of course, we will not save the world. We need to start from our own country. There is a hope we will make it, but let's remember that the fact we will crash, we'll see a crash with the dominant opinion, which is very strong and which permeates the Polish opinion, public opinion, and it deforms the image of reality. The reality and the image of reality are totally different things and different presentations, and that may be really surprising.
Są kluczowe, ale ja bym
Sure, politics is key here, but I'd like to also draw attention to the direction which I think is key in terms of changes in the judiciary as such. I encourage you to be bolder in increasing the democratic mandate of the judges, because they are the representation of the nation after all. This democratic mandate is there in all kinds of forms. Let me refer to the American system, where judges are simply elected. And the sworn judges have the biggest power, who are not professional judges, and they make the most important decision in the process, that is, guilty or not guilty. So the mechanisms for increasing the legal mandate, democratic mandate, are numerous. No system is perfect, because the only perfect system is the final
medium nie będzie panaceum na całe zło wymiaru sprawiedliwości, ale być
the God's court. But this mandate, this democratic mandate, can be supplemented to strengthen that mandate, so that to stress that character, representative character of the nation. Thank you very much. This is the end. Let me just stress that in relationship with the EU, one should be led by pragmatism and not emotion. Thank you very much for this discussion. Thank you.
Raz, dwa. Będziemy już zaczynali, tak? Bardzo prosimy jeszcze panelistów, tak. Jeszcze pan.
N'oubliez pas de le mettre dans le stream. Hein.
Dobrze, to możemy zaczynać. Raz, dwa, trzy. Raz, dwa, raz, dwa, raz, dwa. Raz, dwa. Raz, dwa, raz, dwa, raz, dwa, raz, dwa. Okej, to myślę, że możemy zaczynać. May I? So you need to switch on my microphone. Raz, dwa. Maciek, możemy? Musicie włączyć mi mikrofon. Raz, dwa. O. Tylko potrzebuję sygnał, żeby zacząć. Powiedzcie. Sygnał. Okej. To proszę Państwa, może...
So, ladies and gentlemen, we can now start the last panel. Welcome once again, everybody. Ladies and gentlemen, the topic of this last panel that it's my pleasure to host is whether the EU has the competencies to deal with with the judiciary of the member states. But I think we can take a larger view. I'm happy to have Mr. Jacek Saryusz-Wolski, member of the European Parliament, a person who played a big role in our leading, but also like a member of European Parliament. Welcome, welcome, happy to have you. And on my left, Sebastian Kaleta, Deputy Minister of Justice. Welcome. So, ladies and gentlemen, let's start. Does the EU have competencies in the organization of the judiciary of the member states? Yes? No? What is your take? How do you see that through the political lens, since the processes seem to be very dynamic? Let me start with Mr. Saryusz-Wolski. Because you remember from the very start how things were, how it started, how it evolved, how the competencies changed. How do things look from that perspective? Please stay seated.
Mogę powiedzieć nie. I w zasadzie na tym powinienem zakończyć. Słucham? Teraz będzie przypis do tego nie. Tak, teraz będzie przypis, tak. To jest
My answer is no.
China, który zawsze drąży. O, okej. A nie macie stojaka? You don't have the stand? For the mic? No? Okej. No więc krótka odpowiedź brzmi rzeczywiście tak, Unia Europejska.
So the brief answer is no, the EU has no competence in that respect. The proof is very easy. That's what the treaties say. But in fact, it does want to have the competence, and it starts having some. So I would propose a different perspective than what I see from the agenda. Very juristic, legal, court-wise. My perspective is a political system-wise. And it combines legal and political, because legally the case is closed and clear. No. But politically it's not so obvious anymore. So, what is the context? How are things? It's really impossible to understand the entire battle for the EU competencies to cover the judiciary and member states, particularly in Poland, without taking into account the wider context. And the wider context is, simply speaking, an attempt to take the power. It's an attempt to change the competencies outside the treaties, extend the competencies by infringement of the treaty-based remit. To some extent, what they're doing towards Poland and what they're doing towards Hungary, this is a measure of where the EU is headed and what it's all about. So it's not about the judiciary. Stay assured, dear lawyers, who in the beginning thought it was about legal issues and started explaining why legally it was all right. But my opinion is that it makes no sense to explain things because it's not about legal issues at all. It's a result of a missing analysis of the entire picture systematically, and it's the consequence of this unilateral approach, that is one-dimensional approach, legal-wise. It's about this creeping competence acquisition. There's a lot of literature about that. Articles, books. It's been taking place for several dozen years. Part of the literature is based on the criticism of judges' activism, but taken into account, it's about the political institutional analysis, and it's called the political creep. So if the EU and the central level takes over competencies, this, of course, at the disadvantage of the member states. And which way is it headed? Not towards a federation at all, contrary to what's being said in Poland. I remember Mr. Bronisław Wilczstein. In the 90s, we were in the studio of television that's not there anymore. I talked about treaties, and Mr. Wilczstein brought with him the American Constitution. And the conclusion was, this is so simple, easy, and perfect. Why do you want such a complex document in Europe? To not tell you where the discussion went, but yes, indeed, there is something to that approach. Definitely, we are over-constitutionalized in Europe. Infringement, breach of treaties, I already talked about that, and treaties mentioned 3 rules. The rules that are being breached. They are in Articles 4, 5, and 10. That is the federal, subsidiarity, proportionality, and proximity rules. Article 5 describes the limits of those competencies to the most detail. So treaties are one thing and practice is a different thing, and there's a big mismatch between the two. And in between, there's the aggressive policy of the European institutions to grab competencies that are not theirs. But in our case, it's the judiciary. In Hungary, it's education. But this is not because it's about those competencies. It's because they were well suited to the exercise of political creep. And there's a goal that I call this legal violence of the central institutions of the European Union. And there are 2 components to it. The first one is the method of a repeated lie. A false information repeated over and over again convinces the public opinion that the competencies are there. If you were to check the public opinion, carry out a study, people would say that yes, it's a competency. The judiciary is a competency of the European Union, although it is not. People believe it is, although it's not true. The other goal is to create a precedent. Know that the Anglo-Saxon legal system is based on precedent. It's case law. And there is this Court of Justice ruling where they say, where they talk about the UK case law. But we are not an Anglo-Saxon system. The legal system is not based on rulings. We have written codes from the Roman Code, the Napoleonic Code, etc.
W tej materii,
So convince the public opinion that the competency is there, create a precedent, and based on that conviction, carry out change, execute change. And two sub-variations, sub-options. One, literal, to which the Conference on the Future of Europe was geared, or through the creation of factual change outside the treaties, which is something I'm going to illustrate in a minute. I will show you what that is about. According to the rule defined in the Article 5, the institutions only have the competencies that have been assigned to it. Others are on the part of the member states. Sometimes people say the EU allows this or that, but it's not the case. It's the member states that allow for things, and they grant competencies to the EU or not. And the judiciary is not included in the competencies delegated to the EU. So treaties say that the institutions of the EU should stick with the rules of proximity, subsidiarity, above all. But in practice, that is not respected and it is not being applied. The subsidiarity rule, included in the treaties by Christian Democrats and based in the social teachings of the Catholic Church, says that the decision should be made at as low a level as possible and at a higher level only if it brings added value to the process. Then at the lower level. Similarly, the proportionality rule says that the actions of the EU should not go beyond whatever is necessary. This is a huge simplification, and I want to refer you, ladies and gentlemen, to the document of the Constitutional Commission of the European Parliament, which was printed in 15 copies, also in Polish version. These are 7 documents prepared by the Constitutional Commission for the needs of the Conference of the Future of Europe. 6 were federalist, centralistic, and 1 of a different direction, mine, which wasn't approved. The Commission is completely governed by Spinellists. Examples of the duality of what institutions are doing. I mean the Commission and the Court of Justice. And its ruling is from 2019. The Court of Justice reminds that the Judiciary is under the remit of the member states. So, that's a good thing. But don't be too happy, because after the coma, it is said that the member states have to follow obligations stemming from the European Union law, which means yes but no, for and against. You know that all too well. As the classical way of operating of the institutions, that is, they say, although treaties say quite clearly this or that, but we know better that they wanted to say another thing, etc. It's a kind of violence, legal and institutional violence of the institutions of the EU. And another strand, which I already mentioned, the Court of Justice refers to its rulings as if it were a source of law, case law. It was Article 6, if I'm not mistaken, about the primary character of the EU. There's no such thing as case law like in the UK. So, why us? Why were we chosen? Well, we were the perfect subject of an experiment to be treated as the lab rat, to show how competencies can be taken over and how to work beyond the treaties and how to create precedents. Because, above all, we are a country headed by a very disapproved of government. Outside the sanitary line, the senator is smiling at me, we know what that means. It's an element of political rejection. Secondly, Poland has the boldness to emancipate, to see itself as a subject instead of an object. We are a fundamental threat to the German and French tandem, or the old Carolingian Union, who want to build a centralized, hegemonic, oligarchic EU with only cherry-picked states and cherry-picked mainstream political forces included. And the plan is to combine that under the rule of a concert of power, a directorate. An alliance of such an EU likely centralized, and not federal, because federalism is a doctrine, if we go back to Proudhon, where you can devolve and decentralize as well, which is to the benefit of the local authorities of low level along the rule of subsidiarity. So it's not about federalism, although the basic treaty of federalism, like it's applied, the federations of Germany, Switzerland, and the United States, is that the member parts have equal representation, like in the case of American states, cantons, Bundeslands, while since we've been moving away from Nice, in spite of what everybody has been saying, the EU is moving away from federalism. I don't want to delve into the details, but really, federalism is a mistake. And it's rather, at least, it's federal centralization. If not, it's so that it's clear that we're only going up from the top down and not bottom up. A vertical structure of power is being built from the municipality to institutions that are supranational. And this is the sad picture of the situation. Let me sum up with a question, rather answering a question: what should we do? How can we counteract? The first mechanism is a constitutional shield, a term that has not been used, is not being used enough in Poland. I encourage lawyers to start using it more. It's a term that was created by Barnier when he was in the race for the presidential seat. It's deeply rooted in the concepts of state and law. That is the concept of a constitution that is a barrage is a stronghold against the political crawl, which is being built by the Polish Constitutional Court. Whose ruling we, as a state, are not using. And even in certain opportunities, we are counteracting it. Because the ruling from 2014 was clear, the EU cannot go beyond its remit, and if it does, then it's not binding. While we now have accepted the dictation of Brussels in terms of the judiciary and a few other instances of blackmail, but I don't want to go into more detail. So the first tool is the constitutional shield. Second is apply legal tools to limit the Court of Justice so that it works alongside the principles of subsidiarity and proximity. This is one of my proposals in document number 4 about proportionality and subsidiarity principles. That is the red card procedure, so that certain legal acts can be stopped by decisive action by national parliaments. Red card. And these systemic solutions, there are already yellow card, orange card, but they are not being listened to. And such a red card would be a strong tool if national parliaments could block such legislative action on the part of the EU institutions.
Powołanie czegoś, czego brak, jest dosyć unikalną sytuacją.
It is quite unique as a situation that there is no appeal against the ruling of the European Court of Justice. This is a unilateral decision made by the group of judges, and ambassadors have just appointed additional 7 judges in the first instance. And this body tells us that our judges are not independent, and at the same time it is just an emanation of political decisions and instructions of the government. It's difficult to provide an evidence, but they follow the political instructions, all the judges of the European Court of Justice, which is not a court by definition. So this is the constitutional shield, the second constitutional tribunal. The third one is the appeal against rulings issued by the European Court of Justice, and that causes that the chamber of subsidiarity within European Court of Justice, made of presidents of constitutional tribunal of the member states, who are people who are willing and ready to defend the constitutional identity of their institutions, and all the disputes are around this topic. This is the third instrument in order to construct a dam protecting against this phenomenon. And these are the ideas that I can see for today in order to stop this centralist competence and it is being contested. There was a meeting of constitutional tribunals in Estonia. The constitutional tribunals and courts have gathered. There is some kind of mutiny, but it's not very decided. And the fourth thing, we need to create a political awareness, to raise political awareness. We need to tell people that there are some boundaries and scope of competence that shouldn't be exceeded, and it is not like that. The European Union makes a graceful act and offers us something. So when it comes to the regime and when it comes to the dam, we can count on our supporters from the fraction represented by Marine Le Pen and other politicians who support us and who support this idea. We say no to this plan of hegemonia in Europe and this Eurasia from Lisbon to Vladivostok. I don't know if we succeed, but we should have a go. And for that reason, I would put it like this. First and foremost, we need to organize at the level of expert think tanks, and conferences like this are one step ahead. Additionally, there are some other steps, but okay, let's stop for now, and thank you very much. And now the floor is to a representative of the Ministry of Justice, Sebastian Caleta. Thank you very much. During last few panels, we've been talking a lot about legal matters, and the previous panel and presentation of journalists that suggested and that offered some background. So in order to respond to the question, does the European Union have competence in the organization of the judiciary of the member states? Yes, it is. Can it organize the Council of the Judiciary? No, it has no competence. To the judiciary, when it comes to the organization of the judiciary, it has its competence. I will juxtapose my standpoint to what you've said, starting from Article 85 to 73. These are cases with regard to the common definition of some crimes and offenses. So in some narrow scope, we can define some frameworks for the organization of judiciary at the European level. You do not agree, for example, Euro crimes. It is the same, and it is inscribed in the treaty. So what is the nature of competence and what's not? The European Union can do only and can act only to the extent to which it has been authorized. Is there any directive of regulation on the status of a judge? No, there is no such an act. Is there any directive with regard to mutual approval of rulings? Yes, it is, but because the Union can act to that purpose, it's very important that within this narrow area, all decisions should be taken unanimously. So why everything? What is going on with the judiciary? What are the results of that? When we ask a question about competence, if there is no competence vested in the EU with regard to the judiciary, because a contrario, it's very narrow to, let me remind you that the judiciary is not only the judicial power. So the main axis of the dispute with the European Union, the European Court of Justice has based everything on Article 19, which is a declaration of all member states allowing European Court of Justice whether resources are established by the member states or not, and they serve for the purpose of creation of a common standard. As there is no single standard of organization of the judiciary and there is no treaty article allowing for harmonizing that, the EU has no competence in that respect. And that's very simple. But in the area where European Union says we're entering in the process of pure politics, there is a need on different levels to have this competence, and many environments in the European Union they are satisfied with the process which was started based on this Polish case. It was provided for in one of the member states before because the Constitutional Tribunal of Germany in 1991, when discussing the Lisbon Treaty, they stated that such behavior would be abusing of competence by the European Court of Justice. And when the debate about the Polish reform of the judiciary was on the table, and people were telling that in Germany it was the same and nobody had any problem with that, out of context, the German Constitutional Tribunal, maybe let me read this out because it's very interesting. So this constitutional shield, the German tribunal, knowing what would happen with the Polish case, it showed the European Court of Justice what will be their perception, because they were asked a question about appointment of judges by politicians. So it's FTK of 30th of July 2018 that this competence ends if the interpretation of treaty is not understandable, so it's arbitrary. If the European Court of Justice would exceed this border, the operation of tribunal would not be subject to Article 19, but the ruling of TSUE against Germany wouldn't include the minimum democratic legitimacy required. And what happened next? The European Court of Justice issued its ruling with regard to the appointment of judges by politicians, and they stated that the EU has no competence to interfere with the situation with the appointment of judges. But it was too late, and it would be really difficult to raise doubts about the manner how judges in Germany are appointed. And here, starting from the legal matters and ending with cynical power and politics. So the European Court of Justice came up with the idea that they can evaluate different states, that on the one hand, countries are free to specify the manner of appointment of judges, but at the same time they interfere in these states if they don't like the system, not to destroy the situation in other member states, because the level of politicization here, it's very easy to find out what is the impact of a politician on this entire process. Because if this process does not include, in Germany it was not a problem, but in Poland there was a dispute whether the influence of politicians is 60% or 40% through the procedures, but it will never arrive at the level of 100%. So what was the way out? So a European Court of Justice may select the system arbitrarily, and there is no legal measure. So they indicated that in order to evaluate the independence of judges, there are some principles of law allowing for exemption in the opinion of individuals. So how to measure this being convinced? I don't think that Sędzia Tuleya is independent, and Sędzia Tuleya is of the opinion that Judge Dalkowska is not independent. So whose opinion should prevail? And this is a very subjective matter. All susceptibilities of these authorities to any interest is clear. Additionally, a given authority need to guarantee visible signs of independence, to be trusted as in a democratic state. So subjective, highly subjective measures which prevent us from finding out subjective manner of determination. So with regard to what was said by Dr. Jacek Sariusz-Wolski, this intent to exceed the competence, it's not made through general approval of competence over the organization of the judiciary. This is targeting some specific countries, and this moment, this is all about Poland. So then another country will be selected based on the subjective premises. So each evaluation stands up to the test because it's so subjective. If somebody doesn't trust the court, it is not a court anymore for this individual, and it is allowed by the European Court of Justice as a complete anarchy, and it will not be allowed by the states. Moving towards the scale of the process and the precedence law. Member states didn't ask questions with regard to the organization of the judiciary, and in the last few months we have a real abundance of such preliminary references. For example, a court from Bulgaria asks whether a judge can be delegated by the Minister of Justice. At some point before, when Bulgaria was joining the EU, it was not a problem, and now they start to cut off their institutions and they want to separate even more from this tripartite division. The court in Croatia, these are some specific cases showing that Poland is attacked, and some specific courts are asking questions about institutions being in place for over 10 years. So the president of court needs to be confirmed by the president needs to confirm the ruling. And in Germany, we have another case. For example, Poland needs to prove that it's not a camel to obtain resources from the National Recovery Plan. In Germany, the Code of Civil Procedure assumes that the judge cannot refer preliminary reference to the European Court of Justice. They need to ask a court whether this given question, given request is relevant and whether it serves for any purpose. So what is the cause of this entire process? Everything is about politics here, because there is double standard applied, and it's quite evident that what is allowed in other member states and which raises no doubt in Poland, it's a matter of subjective evaluation, and the reaction may be negative to Poland as the European Court of Justice carries out evaluation based on very subjective premises. So that gives a wide range of arbitrary decisions which are possible, and so one conservative government can be punished because of that. Today, the European Court of Justice doesn't touch upon the judiciary in many countries. They do it on a very selective basis. Put foot in the door, and they will not allow to close that door without calls and rejection from the member state. So that shows that in the Tribunal of Justice, they are exhilarated because they have another area to provide their opinion. For some countries, it works. For others, it doesn't. When we're talking about scenarios, no matter what is the reality, Poland, some new expectations will be forced towards Poland. So Poland devotes itself of veto. In spring of this year, the French wanted to include the hate speech to the list of criminal offenses. We have some human traffic, sexual services, cybersecurity, and other things, and we need to have such definitions in our penal code as all member states, and the EU can impose such a directive with a simple majority, and sometimes falsification of money. And so now, on a list of such serious crimes, they want to add hate speech. Then Poland, there is this Istanbul Convention on the level of the entire EU. So this anti-violence convention. So we were afraid of some pro-LGBT legislation, and this is even more because the European Commission on stalking, cyber stalking, and rape should become trans-border crimes, and they are subject to Article 83, and Poland tries to divide itself of veto, so forcing against treaties. If there is a situation that the European Court of Justice tells that they can interfere without any concrete treaty articles, this is a breach to all things that require unanimous work. For example, Fit for 55, there should be a right of veto. So I'm referring to all these areas in order to let you know that when discussing the judiciary for many years, parallelly there are some processes when the federalization, it doesn't need in many areas any amendment to treaties, because if we define the penal codes and the entire environmental policy, so there will be nothing left for discussion. The main elements of the state, everything from economy to environment, will be transposed to the European directives. And here we are observing the very process of taking over the competence by things that are just made. So this competence is being exceeded. Thank you. If I may, why are we in this place where Poland is being punished? Not only Poland, but also Hungary. And we're informed that rule of law is being we're in breach with the rule of law. Many countries have provided a certain role for Poland. This is a role of a state that can exist, but at the same time it should be subordinate. It should refrain from its own aspirations, and we, as the largest power, can share our zone of influence. So when Poland started to show some aspirations and they wanted to play a greater role, they started to refer to some historically well-known tools. Let me remind you, and the fact that Poland is treated in this way, Professor Andrzej Nowak reminded me that he found something like that in the French books, which are prepared for general schools, the Polish border is presented as an interim border. The problem is that all the processes that are carried out against Poland, it's not anything that we wouldn't know from history. Let me remind you of the Potsdam Treaty, not the one of 1945, but of 1729. And let me quote an excerpt of this treaty between Prussia and Russia.
który mówił o tym, Jego Królewska Mość Pruski
His Royal Highness of Prussia and Russia will oppose any changes and reforms in Poland by word and by action to keep the status quo in Poland, which means that nothing can change in Poland. It can exist, but nothing can change. It can't grow stronger, etc. I remembered this because in the previous presidential campaign, Agnieszka Holland, a celebrity, said during one of her interventions that we cannot let the right to win, because our aim is for things to be as they were, as they are. So precisely what Prussia and Russia agreed on back then in the 18th century. And the problem generally is that 300 years have lapsed, and still it's all about the same thing. Poland can exist, but it cannot be reformed. Back then in the 18th century, around the Third May Constitution, one of the elements of strengthening the state of the Third May Constitution was a discussion about the judiciary. And at the point when Poland did make the effort of reform, it was attacked straight away, so that it didn't grow stronger, because it was obvious that when problems are solved with the reform of the judiciary, etc., Poland would become, not only back then, of course, not only Third May Constitution was about the army, the political system, the non-intervention, and the appointment of the king, etc. Generally, the neighboring countries, external countries, third countries were unhappy with the fact that Poland could grow stronger. And today, the whole rule of law issue is about the same thing. It's just a pretext to strike against such countries as Poland. And generally speaking, people who want to give us lessons don't like democracy. In simple words. The European Constitutional Treaty was mentioned here, which was supposed to guarantee the federalization process. But when the process was rejected in 2 referenda, people didn't like it. So it started being implemented by way of fait accompli. Generally speaking, they have issues with democracy, because Poland is an emanation of democracy, and things have always been so. In the 18th century, and it's typical, Poland was attacked by 3 countries, 3 neighbors, because Poland was the freest country. And the Russian Empire did use the argument of the fact that Poland was too free and it was contagious. It is contagious towards the east. We need to do something about it. And it was an argument that was openly used. And now we are moving to the issue of the Polish National Council of the Judiciary, the KRS. If we're democratic, then every public body should have a part that's chosen by the people. The Article 4 of the Constitution says that the source of the power is the nation. And the thing is that there is a problem with democracy. The old KRS, the 15 judges in the old KRS, that's the system that they want to have as it was. The previous KRS, the group of judges from the highest level of judges decided about who was going to become a judge at the KRS. And that was the majority of the judges that decided about everything. At no stage was there any democratic factor, even a small element, that would demonstrate this democratic mandate. What's changed is that now there is a certain influence of the parliament. That is a body that is democratically elected. After all, if we were to find synthetically the source of the problem with the appointment of judges, you saw that today if we were to talk about rule of law. Our experts demonstrated it. In Poland, the system is very similar to European systems. Poland has no outstanding system in terms of politicization of the appointment system. Quite the opposite. Some systems are very more political. When I raised this argument in the European Parliament, I talked Reinders with Jourova, with the most important politicians who deal with the rule of law. Each time when I raise this issue and I say, you have problems with our appointment system, but it's quite similar to your system and the German system, etc. Each time there's one single answer. That is, look, we have expert opinions, the Venice Commission. Let me read it out. By the way, it was also transposed in court rulings. It's point 5 from the opinion, which says,
systems exist in executive power has a strong influence on appointments. Such system may work well in practice and allow for the independent judiciary because the executive is reinstilled by legal culture and tradition, which have grown over a long time. Czyli co oni mówią? Że owszem.
So what are they saying? They're saying that, indeed, there are systems where the executive power has a stronger influence, indeed. But those systems where there is a better culture and a stronger tradition. The last opinion about rule of law was prepared by the general MEP. If she says there's a better culture and tradition in Germany, so which traditions do they mean? Because to my knowledge, Germany does not have particular achievements in terms of democracy. It was installed by force by Americans after 1945 in practice. So which heritage are they particularly referring to? And giving an answer to that is really problematic. So I'm saying from the very beginning they have assumed that Poland is a worse tradition, a lower culture. And this entire system is just a facade. To prove that, let me quote the previous constitutional court. One journalist asked him at one of the demonstrations. The journalist asked, "What you're doing here, is this in line with the law?" And he thought to himself, and he says, well, it's in line with the need. And that is what the entire story boils down to. They have a certain need, and then they want to execute on it, and the law is just a tool for executing on that need. So let me tell you that the entire story about the rule of law, where it's obvious that it's just a facade, legally and factually, it's a battle for big countries and the countries who feel better than others so that they can dominate countries such as Poland. And the very last strand in my speech, let me tell you that when they use notions such as democracy and that they're doing things in defense of democracy, they're doing quite the opposite. They're doing all they can to have as little democracy as possible. If they wanted more democracy in Europe in the future, then Poland is going to be very important to that. Will Poland survive? Well, for 1,000 years, Poland has been showing to this continent what freedom was and what democracy is. And not the biggest countries like France or Germany have no achievement in terms of republicanism, democracy, and freedom comparable with the Polish achievement. A brief summary, dear Minister. Well, a discussion where everybody agrees with everybody makes no sense. We need to differ. So I'll help you.
Panie ministrze, nie ma kompetencji.
Dear Minister, there are no competencies. The Treaty on the Functioning of the EU, Articles 2 and 3, turned off competencies. There are no shared competencies. There are no competencies in that respect, and that's a foundational problem, error, and the source of our loss. Because we were convinced, and we are a victim of this socio-technical conviction. Cooperation is a different thing. You need to start looking at the EU as an entirety, the history of integration, and not at the details. You need to see the forest instead of the trees. The Venice Commission, I forgot to tell you. The entire reason, the original reason, is rooted in European racism. I used the Venice Commission in my time to play with the situation in backwards countries in Asia and in Africa. It works along the lines that it's better for those backwards countries to go in a certain direction. There's no legitimacy. And Euro-racism theory was applied to us, and we bought into that. I understand, I see why you're opposed to this, but it's about, our not protesting against that at the right stage. And then it's against the treaty. Timmermans and the Commission saying that there are better and worse democracies, and some democracies politicians can appoint and others they cannot, because there are mature democracies like the one that brought Hitler to power, and others are worse because they started with communism. We didn't protest against that. The history of that conflict for competencies cannot be understood if we don't go back to 1957 and to the very start and the Rome Treaty. And the role of the British, who consummated the problem in the form of Brexit. There's a lot of literature on that. Go to the Oxford College. You will see meters and meters of literature about the competency political crawl on the part of the Court of Justice and other institutions. There are long-hour lectures about that at universities. These are competencies that are sourced nowhere. If we are ready to say that such a competency exists, then sorry, but, dear Minister, please don't do that. Dear member, I would like to comment. I know you have the right, but above all, proving that we are not a camel was a mistake from the very beginning. Accepting, talking, it's an old method. If you know the history of the European Union, you will know that since Article 238 of the Treaty of Rome has been applied, it allowed for the competency crawl. Sorry, I can't remember the exact quotation, but it's still alive. It's very old as the Treaty of Rome. So, falling into that pitfall and starting explaining oneself, that's the problem. And suddenly, the situation looks as if you accepted the competencies of the other party. That's the entire problem with the methodology, with the negotiation with the European Union, and going into a discussion with Brussels about the judiciary. That was a very crucial mistake. Lack of holistic approach, comprehensive approach, that's a mistake. Lack of a governmental center that would see the EU as an entirety. There is no center, national center, that would cover the entire EU. There is uncoordinated sum of inter-ministerial policies. The political system of the EU are too important for sexual ministries to deal with them, even the Ministry of Justice or the Ministry of Finance.
Na ustrojowe szalbierstwo, mam na myśli KPO, i drugie, które...
So the one was involved into the matter related with the national recovery plan, and the second got involved in something they shouldn't meddle with. This martyrology, like your heated statements, but it doesn't give us anything. I can listen to you, but your moral supremacy, your historical right, nothing results from that. These are cold bastards. Yes, I know them. I was there. The brutal force and unlawfulness, martyrology, that we are treated badly. Why they do not respond, but they send you to experts because they think you're naive and you're referring to some historical rationale in premises and some moral right, and they make fun of it. Multiplication of examples that here this is unlawful, this is discriminative, and so on and so forth, is losing time and energy, and they want to get us involved in that, and we do not have time and energy to find for it. We need not only diagnosis, the diagnosis is full, is complete, mine and your, we need therapy, what to do about it. You talk to us, I try to call Prime Minister Morawiecki, but he doesn't answer. I will not convince the convinced. Let's move over to the next stage. We have carried out these diagnoses, so now let's continue with actions. We are in defense. We're happy, we're right, and we have such national tradition, we're masochist. And we thought that this is another partition. Let's stop referring to history. Let's fight. Let's go there. Let's go there and get them. We should instigate proceedings against France and Germany. Why didn't we lodge a fight? Because Prime Minister Morawiecki and Minister Szymański didn't agree. We have an application, ready, a lawsuit against Germany. Yeah, I know that. I only don't look smart. I want to move this discussion towards not to leave this room with the awareness that we have convinced ourselves, and then we lose. The climate package. Let's read the statement of the Polish government from last evening. Media inform about consent, and the Polish government said no, and several governments said no. So we, in our moral luxury, we know we're right to fight against this climate and environmental matters, but we're not successful in that. Let's have a look at forest, not trees. Thank you very much, dear ministers. Dear Minister, I'm treating that as intellectual provocation, and it's good that you moved this conversation, but I need to tell you that when it comes to the shared competence, I would not agree. I would not vote for the Lisbon Treaty, but we have it, Article 4, letter J, about justice, so we cannot. No, I don't like this treaty. What is the meaning of these words in the European doctrine? We need to understand this article. This is cooperation in the area where jurisdiction overlap, so where there is the flow of capital, people, and goods and services, and it's also about hard competence of the member states. Going back to historical comparisons, because I need to explain that, I agree with everything with what you've said, and I agree that we need to be strong and say no. We are doing whatever we can, and I'm convinced that the latest example related to the fact that we won't obtain the resources from the national recovery plan is that we did not veto the corporate tax. So it is related. So if we resign from veto, they do not need us for anything. So it is like it works. So I agree that our practice should be changed, not to tell it, but to make ourselves more efficient. And going back to the historical comparisons, I'm not doing that because I like history. Of course, I love history, but I do it because we are in a minority. You know it. One tool of our work is to convince people, to convince other people, other members of parliament and other states, but also Poland, because in the future, out of the several hundreds of MPs, half of them will represent Polish interests and the other the German interests. For that reason, we need to convince also other Polish citizens so as they choose, and this is my tool for convincing them. So if they tell us that if they don't want to learn about constitution, I need to convince them that the Polish constitution was the first in Europe. So this important historical role of Poland is important. This is only one of a few elements, but I will stick to my standpoint. Minister Kaleta, thank you very much. We had a great show of expression, and thanks to the fact that we could meet on site, maybe my reverse rhetoric figure allowed you to and provoked some bitter words towards our political party, and if some decisions are not taken, the only thing that is left is rhetorics. So that may, of course, be concerning. But what I wanted to say, I wanted to present some situation, because we have a potential list of 100 items, and some people think that this is a full list, but only 2 items were changed, as it's 2 in 100. Somebody tells that the glass is full, but it's only in 2%. So for that reason, I indicated that the EU has some competence, because yes, it can issue some shared rulings. They can offer some ruling, and that prevents, and that the Polish court doesn't have to do the same. For example, when it comes to cybersecurity and cyber criminals, we need to adapt to the common market issues. We need to adapt to that and transpose it to our Polish legislation. So, following the reasoning from the greater to the smaller, if only the EU, if there is no principle of law, the EU cannot decide who will be the judge in Poland. So what I wanted to do is to present that if it was the EU to have such competence, it's like the mutual admission of rulings. The EU would need to have some boundary conditions, some minimum conditions for required for appointment of judges, and there is no such principle, so there is no competence. End of story. And with regard to the tactics and this regret, I fully understand with you, and fully agree with you that we are observing year by year how our country is being defeated. We lost too many chances. The decisions are made within some procedure. Nevertheless, you mentioned Germany and some lawsuits against other member states, a list of lawsuits which could be instigated against other member states for defamation. 2 weeks ago, I met some MPs from Bundestag in Warsaw because they came to examine our rule of law, and we said, you should explain that not to ourselves. They said, oh yes, but there are doubts against you, not against us. And this is the whole story. Before some decision is made, because we don't want to make our allies mad or so, it looks as it is. So in the second part, I'm under the impression, and Minister Jaki as well, that you were imagining a totally different person when talking to us, and we convince on our everyday life to other totally other actions. I'm glad we have some prime members to the European Parliament with us among the audience. So now we'll have a short Q&A session. Angel Jamharski, member of the European Parliament, is with us, so maybe we will give the floor to you.
Maybe this. Okay. Dear colleagues, dear honorable members, and dear guests, thank you for this invitation and the interesting discussion. And making this long story short, I truly believe that all matters connected with the judiciary, with the judges, appointing of judges or electing of judges, should stay always into the national state, because judiciary is the core of the national state. And this is the last defense of civil rights. And we all know what is the matter with so-called allegations against Poland regarding the judiciary. This is not a matter of rule of law. No, this is political. This is political from Brussels, because these guys, they want to be in charge. And behind all this, always are a number of NGOs, always. And this is not a matter of rule of law. This is a matter of Brussels' attempt to make a coup in Warsaw, and because they really don't like law and justice, we know this. And this is related with the let's say, the political line of Polish government to protect national values, family values, conservative values, traditional values. And maybe you guessed that here in Brussels, a lot of people are interested not to have these conservative, traditional, national governments in member states. That's why they organize such attack. And it will be always everywhere. This is not a federalism, Mr. Volsky. Behind the federalism, there are a bunch of other ideas, supranational ideas to change our way of building our societies, our education, our judiciary. That's why we truly believe that a number of matters, education, family, and judiciary, should stay always in the national state, always. Yes, we agreed to merge part of our sovereignty, here, but when we are talking about the core of our societies, our core basic roots, we should keep them in Warsaw Polish, in Sofia Bulgarian, in Budapest Hungarian, etc., etc. That's it. And well, there are a lot of things to discuss about constitutions, of course, but still, I truly believe that judges and the whole judicial system in Poland should be appointed or elected by the Polish judges, by the Polish Constitutional Court, or whatever the system in Poland is. Because this is the right way to govern justice in a national state. And this is the point where when I will stop for now. Thank you.
Thank you for your opinion. Thank you. Thank you so much. So, do you have maybe any other question? Czy są jeszcze jakieś pytania?
Any questions from the public? If not, thank you very much for your presence. I'd like to thank you to our dear guests, to the MP and their minister. And officially, let me wrap up this conference. I'd like to thank to all speakers. I think it was highly interesting conference, bringing together important personalities, and it was a great opportunity to share our knowledge. Thank you once again, and goodbye.